Somehow I have mastered the courage to mention this item. On few occasions earlier also took time on behalf of the bank. Can you Lordship give us further 3 weeks time as a last chance? I have intimated the other side.
Item 18,
18, 180.
made by way of 3 weeks.
3 weeks.
It has
Much obliged.
I'm doing listing away WPC law. Listing your 5. Electron illicit network 30. And 9 is on BP law.
Wait, please. Lord, the Laudate Advocate General appearing for the state talked about basically 6 points. My Lord.
So has he completed his argument?
Yes.
Yes, sir. Yes, sir.
Money. My Lord, amongst others,
Yes.
Yes.
Carry on.
Lord, amongst others, one of the points which was asked by the other side was, my Lord, that this OM dated 16th of March 2015, on which we are relying, my Lord, not only it has spent its course that in as much as it is illegal, and it was done by naming the previous government also, it was, I mean, a submission was made that it does not bestow any legal right. Now, the same very government is following this law. The same very government, my lord, the cabinet in its meeting of September 24th approved engagement of temporary faculty in Assam Polytechnic and engineering colleges under Rule 3F of the APSC Limitation of Function Regulation 51, replacing earlier engagement part-time guest facilities. Now, this is important. An office memorandum from the Personnel Department dated 16th of March 2015 provides guidelines for such temporary engagement under Regulation 3F. These temporary appointments, etc., etc. So, they say this is the same very guideline which provides, I mean, OM provides guideline for appointment under 3F. So, to make a submission that this is illegal, anyway, my lord, if it is illegal, you, I mean, set it at naught, which you have not done till date. And nobody is claiming any, I mean, future benefit, my lord. All that we are claiming is an existing right. We say that there are existing rights, it should be considered. So this was one of the main arguments which was argued, therefore I placed it at the very outset. Now, my lord, if your lordships will kindly take the written argument which you have given.
Yes.
Now, one of the points which was asked by the learned Advocate General was, my lord, that the candidates who seeks to rely on the OM they need to fulfill certain conditions. In fact, my lord, there are two conditions. First condition is, I think in clause 4, it is clearly revealed that he should have participated. He should have participated in any selection process. And secondly, my lord, he should not continue in service based on any interim order of the court. Now, these petitioners, they were appointed under Regulation 3F in 2005, and this OM came in 2015. And for this whole decade, my lord, we are working, and we never approached the Honorable Court, neither there was any interim order protecting ourselves. The writ petitions which we filed where interim orders were passed only to the extent that 2 posts of drug inspectors should not be filled. We never prayed for any interim order for continuance of our ad hoc services. So therefore, my lord, this first ground is absolutely without any basis. Now, the criteria is very clear. In fact, my lord, they appointed, if a lordship would kindly come to page 4 of the written argument. Second sentence. In this regard, while passing the impugn order dated 25/4/25, it is clearly been mentioned that a report was submitted by Joint Secretary to the Government of Assam, stating that no irregularities have been found. That is para 5, page 123. However, the said report was neither submitted before the Honorable Court by an affidavit, nor the date of joining and the date of birth was furnished by the respondent. The gradation list of the research assistant working under Directorate of Health Service Assam goes to show that date of joining of Sri Satyan Borua is 7/3/12.
Your demand is that in terms of the directions passed by the court earlier,
Yes,
they have resorted to the same very process and rejected your.
yes.
That's your.
That
case.
is my case is
And
because
your rights accrue under that particular OM,
yes,
and you are similarly placed as the other candidates.
we are already absorbed. And will not there I am heavily relying on the recent judgment of the Honorable Supreme Court. When it comes to regularization, out of the lot, you cannot bestow the benefit upon a few and disregard the others. Can we have the judgment for a moment, Milord?
Raman Kumar.
1 second, sir. No, not 1 second, sir. My lord, the judgment is reported in, my lord, 2023 Live Law Supreme Court 520. There's Raman Kumar. Yes, Raman. In para 8 and 9, it clearly says, my lord, indisputably the appellants herein have completed service of more than 10 years. Even this court in Ravi Verma and others found that act of regularizing the service of some employees and not regularizing the sum of others is discriminatory and violative of Article 14 of the Constitution of India. Mrs. Ashwarya Vattir, other additional Solicitor General of India, appearing on behalf of the respondent, have vehemently opposed the petitions to submit that since the posts were not available and thereafter Group D posts have been abolished, the appellant could not have been regularized. We are not inclined to accept the submission made on behalf of the respondent. And the Chief Commissioner of Income Tax has himself found that 65 persons were entitled to be regularized. The act of regularizing services of only 35 employees and not regularizing the service of others, including the appellant, is patently discriminatory and violative of Article 14. So, my lord, you couldn't have ignored our case because similarly situated person, pursuant to direction issued by this Honorable Court in Social Welfare Department, in Health Department, they have been regularized. These two petitioners have been not regularized on the grounds that the OM is bad, etc., etc. Now, when it transpires, government has implemented the same OM when it comes to making 3F appointment. Now, my lord, the other point. So, my lord, these two gentlemen, Satyan Borua and Rafiqur Rahman, they did not even completed that minimum 9 years period. Yet they were appointed. This Satyan Borua and Rafiqur Rahman. And my lord, if your lordship could kindly come to their lordship's earlier judgment, which is very important, last para of the judgment. If you lordship to kindly come to page 119 of the writ petition. Para 17. After noticing the facts, how appointments were made, para 17 at page 119. Under such circumstances, this court is of the considered view that matter will require fresh consideration in the hands of the government for considering the case of the petitioners for regularization in terms of the OM dated 16th of March 2015. Government will examine the case of the petitioners as also the contention raised before this court that several incumbents are regularized, who are given the benefit of regularization under OM, did not fulfill the criteria, but nevertheless the benefit of regularization was conferred. So Lordships took note of the fact that some of the incumbents whose services were regularized, they strictly did not fulfill the requirements envisaged by the OM, and yet they were. It was having regard to those facts, Lordships directed that you give a fresh look to the whole issue. Now this order has attained finality, there is no order. Now the two grounds on which, my lord, again the application has been rejected is on two grounds, that is, that we never participated in any selection process, and secondly, we are not entitled to the benefit of age relaxation. On the contrary, my lord, from 2005 to 2015, when the OM was issued, we have already completed 10 years. There was neither any selection process initiated by the department for regular recruitment, nor, my lord, we rendered our service on the strength of any interim order. So therefore, the question of rejecting our case does not arise. Then, my lord, will kindly come to page 5, my lord, where the second point which was asked by the learned Advocate General was that it was a one-time measure and it cannot be resorted to in future. I think, my lord, there is a basic fallacy in that argument. Nobody is asking your lordships to fulfill the, implement the OM in the future. In fact, we are saying we have a vested right and that right should be considered. Now, point number 3, my lord, we have basically said that the OM envisages two conditions. Cases where incumbents have not appeared in APSC and cases which are sub judice. So this I have already dealt with, my lord. Therefore, I need not trouble your lordship. Then point number 4, that is the same point, my lord, from 2005 till 2015, we all, my lord, served without any order of the Honorable Court, and there was no advertisement. Now, point number 5 is very important. That I will have to deal with little bit. Now, here the learned Advocate General submitted, my lord, that our last extension was in November 2023, and therefore thereafter our services have not been extended. Now, my lord, we have in point number 5, we have tried to explain the position that extensions are given even after 2 years of. It's not that they follow in any uniform policy or something. And my lord, even today we are performing our duty, and we have been delegated duties which were brought out in the writ petition, and more particularly in the affidavit in reply. If your lordship should kindly have the affidavit in reply. Now, if your lordship should kindly come to page 232, my lord, that's part of our affidavit in reply. Page 232, my lord. This is a communication of 5/2/24. to the from Drug Controller and Licensing Authority to PS Mudoy and Pankaj Kakoti. With reference to the subject cited above, you are hereby deputed for counting of ballot papers on 24 to 24 at 9 a.m. in Assam Pharmacy Council as requested by the returning officer, Assam Pharmacy Council. Then Milord will kindly come to page 234. Kindly see, Milord, this is an order passed by the director, member secretary, Assam State.
234.
Milord.
234.
Four.
34 is para 18.
No, Milord, it's an order dated 28th of May 24. I'm relying on the reply affidavit.
58 of
In Purno Sindhu, Milord, in WBC 2137. 28 May. WPC 2137. Two 34. A joint team comprising of the following officials are hereby nominated for assessment of NBTC guideline and to assess the existing blood, etc., etc. Please come to see, Milord. PS Mudoy. That's the petitioner. Then Milord will kindly come to page number 237. And Milord, this is again by the Superintendent of Railway Police, Milord. Now to the drug controller, then the drug controller in his turn, Milord, on the right hand side on top. Please put up Deputy PS Mudoy. There's an endorsement by the Lord this drug controller. Then Milord will kindly come to next page, page 238. From Commissioner, Food Safety and Drug Administration, Assam, to Commissioner and Secretary, Government of Assam. Permission to attend national level review consultation on implementation of Joint Action Plan on prevention of drug and substance abuse and illicit trafficking on so and so. With reference to the above, I have the honor to inform you that National Commission for Protection of Child Rights, New Delhi, has organized the national level review consultation on implementation of the Joint Action Plan on prevention of drug and substance abuse and illicit trafficking on 30th of June 2024 at Vikan Bhavan. The Honorable Chairman, etc., etc. Now, on the next. The Honorable Chairman, National Commission for Protection of Child Rights, has requested to nominate one officer to attend the review meeting. In this regard, Commissioner has recommended PS Mudoy, Inspector of Drugs, Kamrup M to attend the said meeting. This was on 24/6. Then, Milord, on the next page, in August, 22nd of August 2024, now this is again a communication from Joint Secretary Health to Commissioner and Food Safety. With reference to the subject and letter cited above, I am directed to convey the approval of Government of Assam in Health and Family Welfare Department for attending second National Congress workshop on Mumbai. That serial number 5 and 6 are the two petitioners. So this is how, Milord, we are continuing. So this contention also, Milord, failed. Now, Milord, the most important point is, now an impression is sought to be given by the learned Advocate General that, my Lord, after Uma Devi's judgment, regularization is something which is incomprehensible. That, with all respect, I will submit, my Lord. Uma Devi, in my humble understanding, my Lord, is more of a restraint on the court not to issue direction for regularization. But, my lord, Umadevi has never divested the executive of its power to frame an appropriate scheme if the situation so warrants. Now, here is a case, my lord, we are relying upon the office memorandum of the state of Assam, which confers the right of consideration. Now, in that circumstance, with all respect, how, my lord, this argument is relevant, my lord? In any case, my lord, Umadevi has been misconstrued by the state all throughout. Now, a series of judgments, Honorable Supreme Court has clarified, my lord. In fact, one judgment I'll place, that is, my lord, the Jammu and Kashmir case. Yes. State of Jammu and Kashmir versus District Bar Association, Bandipur. Lord, I can hand over the book. 2017 3 SCC 410. Please come to para 11. Sir. Okay. Yes. Lord, I'll have your lordship kind attention to page 422, para 11. The decision in Umadevi dealt firstly with the basis of long continuance, legitimate expectation, employment under the state and directive principle. The second salient question which the Constitution bench was called upon to answer was whether the court should be justified in issuing direction for regularization based on such features as equality and long spell of service. On both counts, Constitution bench held that temporary employees on both counts of Constitution bench held against the temporary employees. That means, my lord, the power of the court has been circumscribed. But this, however, this is very important. However, Umadevi is not an authority for the proposition that executive or legislature cannot frame a scheme for regularization. Umadevi does not denude the state or its instrumentalities from framing a scheme for regularization. So I am on this matter. Now, state has framed a scheme. Now, state has not recalled that scheme, my lord. Though the learned Advocate General orally made a submission, on the contrary, the practice which is being followed is state is following that. The Education Minister himself has, come out with that tweet. So therefore, all that we are asking for is to, my lord, give us the benefit of that scheme which you have given to others. We are nothing asked. We are not, seeking any direction from this honorable court for regularization. All that we are asking for is state should implement its own aim dispassionately and, my lord, rationally. And as you have regularized the services of others, please give us the same benefit. My lord, I have already placed those judgments, my lord, while opening my argument. The decision in Sripal and Jaco, my lord. So I will not repeat those, but I will rely upon one judgment of the Supreme Court. Recently, it was given where a direction for regularization was given by the High Court, against which, my lord, the state of Madhya Pradesh referred in SLP, which was rejected. Please come to, my lord, para 5. It is true that an employee engaged on daily wages has no legally vested right to seek regularization of his services. However, if the competent authority takes a policy decision within the permissible framework, its benefit must be extended to all those who fall within the parameter of such a policy. Authorities cannot be permitted to pick and choose in such circumstances. The fact that respondent number 1 has worked as a daily wager from 2005 to 2009 is not in dispute. Eligibility for the post he holds has also not been controverted. The fact that he initially entered the process in conformity with Article 14 and 16 of the Constitution is also not a serious issue. That being so, we see no reason to interfere with the impugn order passed by the High Court, directing petitioners to confer the status of regular employee on respondent number 1. So, my lord, once there is a policy, once the entry into the service is not illegal, that is by following some process of law, then everybody is entitled to, my lord, the dicta laid down by the Supreme Court in para 53 of Umadevi. But to contend that Umadevi bars regularization, my lord, at least that argument does not hold good in this present case, at least in the present fact scenario. Here we are not seeking any direction from your lordship that minus that 16/3/2015 OM, we are seeking a direction. No. Already a policy of the state stands. We are saying, please extend that policy to us as we have done to others who are similarly identically placed like the petition. So that being the position, my lord, lordship will allow the repetition, my lord, with all consequential relief. My lord, for my satisfaction, I may be permitted to read finally one paragraph from the Jagus case, my lord, which is, my lord, the civil appeal number, SLP number 5580 of 24, para 18. Appellants have also established that individuals with lesser tenure or comparable role were regularized by the respondent. The council body appellants have submitted a seniority list for the employees working as multitasking staff published by the respondent department on 4/3/24, wherein the following employees were a part of the staff without the required educational qualification. A bare perusal of the aforementioned list shows the preferential treatment accorded to these individuals despite their shorter service duration and no educational qualification. This exemplifies discriminatory behavior and lack of uniformity in the respondent department's approach. Such disparity violates principles of equality enshrined in Article 14 and 16 of the Constitution and cannot be sustained. It is evident from the foregoing that appellants' roles were not only essential but also indistinguishable from those regular employees. Their sustained contribution over extended period, coupled with the absence of any adverse record, warrant equitable treatment and regularization of their service. Therefore, my lord, in para 20, what was dealt with was that these appointments were not back. At the end of the day, my lord, my humble submission is, my lord, we are not pleading negative equality as such. All that we are saying is, my lord, please extend a similar consideration as you have extended to others. Though you profess to say that they were in a different footing, in fact, not. In fact, my lord, the two persons in the health department, they did not even complete 9 years. We are not saying because they were given, give us. No. Our case is we fulfill the requirements envisaged by the OM. Therefore, please consider our case. And your lordship's earlier direction has attained finality. No appeal has been filed. Therefore, on the same very old two grounds, they cannot again reject my case. Therefore, the rejection is arbitrary and they should be given a direction to consider our. That is my. I'm deeply. Deeply.
And Lord, interim order is there, Lord. That may be continued.
You don't need a separate order.
Hello.
Senior, you can let me take up the matter after.
That courtesy you have to extend to the council on the other side.
Senior has already finished his part. I am replying.
You want an adjournment before 10:30, you should have,
My lord, if you want an adjournment, the matter. My senior will appear in the
oh,
matter.
that's right, but that, inform the other side, that's a courtesy, there's no rule. The courtesy you should extend, that's all.
I would not have.
We'll
troubled
take it
my-
up after a while,
Yeah,
if you are
yeah.
available otherwise.
No, I am available, but government side has already finished their submission, and therefore I am only on reply. I started on the last officer.
You know
Therefore,
the anxiety on the other side of not being present when the
reply.
reply is being made. So perhaps that's the only
They
anxiety.
will make a note.
We can take it up after a while, subject to your.
True, but my lord, I am told that the next items are also very lengthy.
All items are lengthy that way.
That is why I want to be short and over.
Yes,
Lord, my senior will also.
Then he will make submission.
we'll defer it by 1 hour max. By 12:30 we'll take it.
Much.
Present. But at 12.
Please, Mike.
Lord, the issue arises under the GST law, Lord. And may I request my Lord, please see the interim order parts because it fairly summarizes all the issues. May I draw my Lord's attention to the order of 13/12/23, my lord. My Lord, have that.
Yes.
May I read, my Lord? Heard so and so, my Lord, para 2. In this writ petition instituted under Article 226 of the Constitution of India, a sale is made by the petitioner to a demand come show cause notice dated so and so, issued by respondent number 2 under section 73(1) of the Central Goods and Services Act 2017, whereby the petitioner company has been called upon to show cause why input tax credit wrongly availed amounting to so and so for the financial year 17-18 in terms of section 73(1) read with notification 9 of 23 and the corresponding section 2, why applicable interest on the wrongly availed ITC should not be recovered. 3, penalty on the wrongly availed ITC should not be recovered. My Lord, have that. Para 3. Section 73 of the CGST Act has provided for a determination of tax not paid or short paid or erroneously refunded. My Lord, this is a recitation of the section. Para 4. As per the demand show cause notice, it appeared to respondent number 2 as the proper officer that there is an unreconciled ITC amount amounting to 19.51 crore as reflected in the GSTR 9C for the financial year 17-18. And the noticee petitioner company is required to reverse the wrongly availed ITC under section 73(1). The said notice has been issued finding a discrepancy purportedly under section 61 of the CGST Act. My lords, then the submissions which I made at that stage. The contention advanced on behalf of the petitioner is that the provisions contained in section 61 of the Act read with rule 99 of the rule require the proper officer to scrutinize the return and related particulars furnished by the registered person to verify the correctness of the return with reference to the information available with him. In the event any discrepancy is noticed, the proper officer has to issue a notice to the registered person in form GST ASMT 10. My lords, one of the jurisdictional issues is this notice has not been issued. and they have accepted the fact it is not issued. In the event any discrepancy is noticed, the proper officer has to issue a notice to the registered person in Form GST SMT 10, informing him of such discrepancy, and has to seek explanation thereto within the prescribed time period. On receipt of the notice, the registered person may accept the discrepancy mentioned on the notice and pay the tax, interest, and any other amount arising from such discrepancy and inform the same, or furnish an explanation for the discrepancy in Form GST ASMT 11 to the proper officer. Where the explanation furnished by the registered person is found to be acceptable, the proper officer shall inform him accordingly in Form GST ASMT 12, and no further action shall be taken thereafter. If no satisfactory explanation is furnished within the stipulated period of being informed by the proper officer, or where the registered person, after accepting the discrepancy, fails to take corrective measures in his return for the period in which the discrepancy is accepted, the proper officer may proceed to determine the tax and other dues under Section 73. My lord, I'll just state it in a nutshell. The jurisdictional issue is this is a proceeding under Section 61, saying there's a discrepancy. The law would have required, under a reading of Section 61 with 99, Rule 99, that an ASMT 10 notice should have been issued. In this case, it has not been issued. Once that notice is issued, I could offer an explanation. If my explanation was offered, the matter comes to a quietus. If my explanation is not accepted, then it proceeds to a Section 73. Here it has proceeded to a Section 73 notice without any of the jurisdictional requirements under Section 61 or Rule 99 being followed. That was, my lords, our case as stated at that stage, continues to be our case. The second issue, it is the further contention of the petitioner that the impugned demand cum show cause note. The alleged discrepancy is that the petitioner company did not submit information in Table 14 in Form GSTR 9C, and as a result, there was a mismatch with the details furnished in Form GSTR 9. Form GSTR 9C with the table contains details as to reconciliation of ITC declared in the annual return with the ITC availed on expenses as per the audited financial statement of books of accounts. By notification 56 of 2019, notification 79 of 2020, notification 30 of 21, etc., submission of information in table of Form GSTR 9C has been made optional for the financial years 17-18, 18-19, 19-20, 21-22, 22-23. My issue is only for 17-18. It is thus contended that since the submission of information in Table 14 in Form GSTR 9C has been made optional, there cannot be any error or discrepancy from the non-filing of information on the part of the petitioner in Table 14 of GSTR Form 9C. This was the second limb of my argument, that the claim discrepancy arises because they say that you have not appropriately filled in Form 14, the Table 14 in Form GSTR 9C. This very table and the filling in of this table was made optional by various notifications and amendment to the rules. We are therefore saying that when I exercise the option not to fill in details, there can be no question of a discrepancy. This was the second limb of my argument. Para 7, my lord. With such contentions, it has been contended that the mandatory conditions precedent for invoking the provisions of 73(1) for issuance of a demand cum show cause notice are palpably absent in the case in hand. Mr. Kayal, standing counsel GST, on basis of instructions received by him, vide communication number so-and-so, has submitted that the petitioner company was informed several times regarding the discrepancy letters dated so-and-so, so-and-so, so-and-so by the authority. My lord, the next sentence is critical. It has, however, been admitted that the Form GST ASMT 10 was not issued by the range. This they have now confirmed in their affidavit at page 186, para 19. My lord will find that they accept that there is no ASMT 10. He has contended that the non-issuance of the Form GST ASMT 10 does not result in violating the basic principles of natural justice, since the demand cum show cause notice has been issued to the petitioner as the assessee, and the same is in conformity with the principles of natural justice. Then, my lords, he raised issues on maintainability, saying there's alternate remedy. Reliance is placed on the decisions of the Honorable Supreme Court in Pola Marmo Agglomerates and Union of India versus Coastal Container Transporters Association. Para 9, in response, Mr. Shah has submitted that the issues in this writ petition are not relatable to any disputed questions of fact, but the issues are relatable to a non-adherence to the statutory prescription prescribed in the CGST Act and the rules. The issues raised are whether the existence of the jurisdictional fact for the proper officer to issue the demand cum show cause notice under subsection 1 of section 73 at the time of its issuance. It is thus contended that if the question of lack of jurisdiction is involved, a writ petition under 226 is not only maintainable but entertainable. He has placed reliance in the 3 judges bench decision in Magad Sugar and Energy reported at so-and-so, wherein references have also been made to the decisions in Whirlpool and in Harbanslal Sahani versus Indian Oil Corporation. The matter would require further examination. Issue notice, so-and-so, para 13, my lord. The respondents in Pola Marmo were served with a show cause notice as why the agglomerated marble should not be exigible to excise duty. The Honorable Supreme Court of India found that the question involved was a question of fact, whether the properties and characteristics of agglomerated marble remains the same as those of excavated marble. Having found that the High Court were going into the issues of fact, it has been observed that the High Court should not have interfered in a writ at the stage of show cause notice to take over the fact-finding investigation. In Coastal Container Transporter, the Honorable Supreme Court has observed that the writ under 226 was preferred at the stage of show cause, and has further found that the case was neither a case of lack of jurisdiction, which is this case, nor is it involving any violation of the principle of natural justice, so as to entertain the writ at the stage of show cause. It was found that there was a serious dispute with regard to the classification of service, and as such, the respondent ought to have responded to the show cause by placing material in support of their stand instead of approaching the High Court questioning the show cause. In Magad Sugar, the High Court declined to
It was
enter.
issued because it was held to be jurisdictionally.
Absolutely. We
not a
said
question
that
of
a
fact.
fundamental jurisdictional fact, namely the ASMT 10 issuance, as a precursor to the issuance of 73, and complying with the entirety of Section 61 and Rule 99, those were jurisdictional preconditions, not that.
At the moment, may have given a prediction, may have considered, may not have.
Absolutely. And then, my lord, all of these circumstances contemplated in Section 61 and 99, Rule 99, would then have transpired because it contemplates 3 things. 1, I get notice. There are 3 scenarios thereafter. I give an explanation. The explanation is found acceptable. Then by prescription of law, under 61(2), the matter comes to a quietus, statutory. The other situation is, I accept the liability. In one case, I will pay. But if I accept liability and don't pay, then the matter can proceed further. Third scenario is, my explanation is not an acceptable explanation. In scenario 2 and 3, where I accept liability but don't pay, or I don't give an explanation which is acceptable, the matter can then proceed to Section 73. This is the statutory scheme, my lord. And failing that statutory scheme, the situation we are saying is that the Section 73 notice is bad in its inception because the necessary prescription of the law is not followed. Now, my lord, since we filed here, we also have the benefit of a judgment of the Rajasthan High Court, which has said that if you don't follow 61, the 73 and the subsequent order all effectively go. That Rajasthan High Court judgment has gone up to Supreme Court. They've refused to entertain the department's appeal.
You're saying it that's covered by the judge.
Yes, it stands covered by the Rajasthan High Court judgment, my lord. If I might and my lords would permit, may I just read through the next two paras, and then may I just show my lords section 61 and rule 99. Yeah. Would my lord
Yes.
just
Yes.
my lord, if I might just read para 14 and then come para 15 in the interim order itself. The issues raised in the present petition prima facie are not related to any disputed questions of fact. Petitioner has raised the condition that the statutory prescription contained in section 61 and 73, read with rule 99, have not been adhered to, and without adherence to the condition preceding, that is issuance of notice to the registered person in form GST SMT 10 to provide the noticee either to accept or not accept the discrepancy, or to furnish an explanation for discrepancy, or to not furnish any explanation at a period of time anterior to the impugned demand cum show cause notice, the proper officer could not have assumed jurisdiction to issue the demand cum show cause notice under subsection 1 of 73. Prior to the issuance of notice under 73, it is a mere discrepancy. At that stage, the alleged discrepancy would only be a discrepancy simpliciter, but at the stage of the issue of the show cause notice, there is a formation of a prima facie opinion on the part of the proper officer that there is an act which is in violation of the statutory obligations cast under notice. My lord, that para 14, would my lord only please notice this. Admittedly, in the case in hand, the form GST SMT 10 was not issued to the petitioner. My lords have noticed. A contention has also been raised that the CAG is not the proper officer to issue any kind of letter. Prima facie, the court finds force in the above contentions advanced by the petitioner that an act of issuance of the demand cum show cause under 73 was without compliance of the mandatory conditions precedent prescribed under the GST Act and the rules, more particularly the provisions of section 61, read with rule 99, to derive jurisdiction to issue such show cause cum demand notice. In view of the same, it is ordered that the operation of the impugned demand notice be stayed till the returnable date. My lords have seen this. May I just, my lord, show the show cause to show that it is under section 61. Then I'll show my lord section 61 and rule 99, and then we can go to the Rajasthan judgment. My lord, the show cause is to be found in the writ petition at page 54, my.
Yeah.
My lords have that. My lords, it says it's a demand cum show cause notice issued under section 73(1). My lords have that. In the center of the page, demand cum show cause notice issued under section 73(1). My lords have that.
Yes.
My lords will see para 2. Whereas it appears that as per section 61 of the CGST Act, the GSTR 9 and GSTR 9C returns related to FY 1718 were taken up for scrutiny, while examining the GSTR 9 and GSTR 9C at a data level to review the extent of identified mismatch in the ITC declared in the annual return with the expenses reported in the financial statements, the officers of the Directorate General of Audit, Calcutta, observed that the noticee had an unreconciled ITC of so and so. So, my lord, it's squarely a proceeding under section 61. And my lords will see over the page, page 55, at para 3, my lord, they have set out the entire scheme, the relevant provision of section 61. My lords have that. And therefore, my lords, it's squarely a proceeding under 61. Now, my lords, if I might just call my lord's attention to the relevant provision, my lords, we handed over a compilation if my lords have it, or I can show it from the petition itself.
Violation is not here. But
I don't need to,
it's not.
my lord, it was given, but I don't need to detain my lord. Would my lords please see page 93 of my petition?
Yeah.
Would my lord see page 90?
93 of your compilation.
My lord, if my lord has my compilation, please see page 93 of my compilation. If not, my lords can see page 164 of
Yes,
my
we
petition.
have your compilation.
My lords would please see page 93, my lord.
Yes.
May I read, my lord? Section 61, scrutiny of return. The proper officer may scrutinize the return and the related particulars furnished by the registered person to verify the correctness of the return and inform him of the discrepancies noticed, if any, in such manner as may be prescribed. My lords, the prescription of the manner is in Rule 99. I'll just go there and seek his explanation there too. 61.2. In case the explanation is found acceptable, the registered person shall be informed accordingly and no further action shall be taken. So, my lords, in 61.2, if you give me a notice, I give you an explanation. The proper officer applies his mind. If he sees it is acceptable, then he must inform and nothing further happens. If not, my lords, we go to 3. In case no satisfactory explanation is furnished within a period of 30 days of being informed by the proper officer, such further period as may be permitted, or whether registered person, after accepting the discrepancy, fails to take corrective measures in his return for the month in which the discrepancy is accepted, the proper officer may initiate appropriate action, including those under section 65 or 66 or 67, or proceed to determine the tax and other dues under section 73. My lords, mine is a notice under 73. He's gone straight to 73 without having given me the ASMT 10 notice. Would my lord see the next page, page 94? That is where Rule 99 is set up. My lords have that?
94.
Yes. Rule 99 is set out. My lords have that. So what 61.1 refers to as the prescribed procedure, that prescribed procedure is mandated in Rule 99. Where any return furnished by a registered person is selected for scrutiny, proper officer shall scrutinize the same in accordance with the provisions of section 61 with reference to the information available with him. And in case of any discrepancy, he shall issue a notice. My lords have noticed the word shall, it's a mandate. He shall issue a notice to the said person in form GST SMT 10, informing him of such discrepancy and seeking his explanation thereto within such time, not exceeding 30 days from the date of service of the notice, or such further period as may be permitted by him, and also, where possible, quantifying the amount of tax, interest, and any other amount payable in relation to such discrepancy. The registered person may accept the discrepancy mentioned in the notice issued under Subrule 1 and pay the tax, interest, and any other amount arising from such discrepancy and inform the same or furnish an explanation for the discrepancy in Form GST ASMT 11 to the proper officer. Where the explanation furnished by the registered person or the information submitted under Subrule 2 is found to be acceptable, the proper officer shall inform him accordingly in Form GST ASMT 12. And my lord, if the explanation is not acceptable, then we would go back to 61.3 over the page. And in that scenario, the proceedings could then progress further to the issuance of a show cause notice under section 73.
This is section 99 you are referring
My lord, Rule 90.
to. Rule 9.
Over the page is section 61 at page 93.
And this is rule 9.
This is rule 99, my lord. And this is the rule under which the procedure as contemplated in 61.1 is prescribed. May I call attention to 61.1?
Yes.
The proper officer may scrutinize the return and related particulars furnished by the registered person to verify the correctness of the return and inform him of the discrepancies noticed, if any, in such manner as may be prescribed. My lords have seen that. That prescription, when we go to rule 99.1, that prescription is that he must issue a notice in form GST ASMT 10. My lords have seen that.
Which was not done.
Which was not done, admittedly. Now, my lords, if I might, my lord, the scheme essentially, as my lords are aware, if there is a short payment of tax, non-payment of tax, wrongful availment of ITC, either under section 73 or 74, a proceeding can be initiated by the proper officer. This is a situation where, therefore, the proper officer has formed a view that there is some sort of short payment or excess availment, and he puts you to notice. This is the normal procedure. In the context of section 61, there is a special procedure which precedes section 73. And that special procedure is a procedure which allows either for resolution or payment. But if neither resolution or payment can occur, it then migrates the issue and escalates it to section 73. But this procedure, my lord, is therefore a specially prescribed procedure to find resolution in one of three ways. My lords, if we read 61 and 99 together, section 61 and rule 99 together, the elements of what is prescribed as the pre-show cause notice procedure under 73. My lords, if I may summarize the elements, they take up my returns for scrutiny. If they find a discrepancy, they must issue me a notice under the GST ASMT 10. Upon this notice coming, I have two options. One, I accept the liability, I pay the amount. Issue closes. I don't need to go to 70. Second, I give an explanation, and that explanation, my lords, is found satisfactory. If found satisfactory, he must then issue me a GST ASMT 12, which is what is contemplated in 99.3. And if he issues that, then under 61.2, the matter comes to a quietus. That's the end of it. If, however, I accept liability but don't pay, or my explanation is not satisfactory, then in that situation, my lords, after exhausting all the other prescribed steps, I then come under 61.3. And under 61.3, if all the other steps as prescribed under 61.1 and 61.2 read with 99, if all those are exhausted and there is no resolution, then alone the matter can go to section 73. Now, what has happened here is completely forsaking what is prescribed under 61.1 and rule 99. What we have is a notice under 73. So they asked me, he says that he gave me intimation of hearings, etc. My situation was, since you have not satisfied the jurisdictional facts prescribed under 61 and 99, your notice under 73 is back. Now, my lords, that being my submission, my lords have seen that it is recorded in the interim order that there was no ASMT 10. May I just call attention to their affidavit? And if my lords will see running page 186 at paragraph 19. 186, paragraph 19. This is the tax department's affidavit. My lords have it. My lords, This was filed on 17/4/24.
Yeah.
It begins at, my lord, I think it begins at 179. Can I call attention, my lord, to page 186? Would my lord see para 19? With regard to the averment made in paragraph 17 of the writ petition, the answering respondent states that non-issuance of ASMT 10 does not violate the basic principles of natural justice, since a show cause was issued to the assessee to adhere with natural justice. So what they are saying is, I have not given ASMT 10, but because I have given section 73, there is a compliance with natural justice. My lord, which misses the point completely, that when there is a process prescribed under 61 and 99, non-following of that process itself renders the 73 proceedings without authority of law. And therefore, it's not just an issue of opportunity. It's an issue of non-satisfaction of the prescribed statutory jurisdictional fact and jurisdictional act. That not having been done, it is bad in law. Now, my lords, before we go to the Rajasthan judgment, may I just show that not only is this the prescription of the law, which they are bound by, and my lords are aware that there is a whole line of Supreme Court judgments, starting with Bhavnagar University, that when you have a tax statute or any such statute, the officer is a creature of statute. And the prescription of law, therefore, that the Supreme Court elevates to the point of saying that an officer who is a creature of statute must act in terms of the statute or not at all. And I'll show those judgments to you. So therefore, when an officer of the tax department, who is a creature of the tax statute, chooses to act contrary to the statute, my lords, that act is a nullity. And if that act is a nullity, my lords, that is why we are before my lord, seeking that the show cause should effectively be set aside. Now, my lord, if I'll just point to the, besides the statute, my lords are aware that they issue circulars from time to time, which Supreme Court has also said are completely binding on them. Now, in this context, my lords, will please see my writ at page 166. There is a standard operating procedure which was prescribed. My writ petition at 166. My lords have that. Yeah, Annexure 10, man. Page 166. May I read, my lord?
Yes.
My lords, this is issued on 22nd of March 22. This is issued, as my lords will see, to all principal chief commissioners, principal commissioners, and commissioners of central tax, all principal director generals and director generals of central tax. Standard operating procedure for scrutiny for financial year 17-18. My lords have that. And 18-19. My lords, I have my writ petition.
Yes, yes.
Yeah. So, my lords, my year is 17-18, for which this demand is. Now, section 61 of the CGST Act, read with rule 99 of the CGST rules, provides for a scrutiny of returns and related particulars
What is
furnished
this?
by the register.
What is this? This is an SOP for scrutiny.
Yes, my lord. My lords are aware that for the purposes of ensuring administrative uniformity, there is a right to issue circulars and to issue different sorts of SOP. So here they've issued this SOP relevant to any scrutiny under section 61, which is my case. And my lords will see this. The prescription, my lords are seeing at page 166 at para 2, my lord, they reproduce section 61. Over the page at 167, my lords, they reproduce 99. Now, my lord, please see para 2.2. In 2.2, would my lords come to see, informing the registered person of the discrepancy noticed, if any, along with quantification, of tax, interest, and any other amount in relation to such discrepancy and seeking his explanation. My lords, the two important aspects is issue a notice, and if he gives an explanation, apply your mind to that explanation. Now, my lords, will come over the page at 169. Would my lord see para 6.4? The proper officer shall issue a notice to the registered person in form GST SMT 10, informing him of the discrepancies noticed and seeking his explanation thereto. Then my lords will see 6.7.
Yes.
Where if the explanation is furnished and it is found to be acceptable, he shall conclude the proceedings by issuing a form GST SMT 12. And 6.8, that in case no satisfactory explanation is furnished, then they can proceed, my lords. Under 6.8, they may proceed, my lords will see in the 5th line, to determine the tax and other dues under section 73. My lords have that.
Yes.
And my lords, over the page at 170, they have set out a table of the sequence of events, how the events need to sequentially proceed, and what are the timelines. Now, my lords, if my lord sees 7.1, serial number 5 in the table, my lords have that, is the para 7.1 in the table, serial number 5, issuance of notice by the proper officer for intimating discrepancies in form GST SMT 10. My lords have that. Then next step, my reply in form GST ASMT 11. Then next step, if he accepts, he must issue the form GST ASMT 12. And if after all of this, there is no satisfactory explanation, then the next step, which is initiation of the appropriate action under section 73. My lords have that. So my lords, both by the clear language of the provisions and by the guidance offered by the SOP, there is no manner of doubt that there is a prescribed sequence of events which must precede the issuance of a section 73 notice if they are proceeding under section 61. I have shown, my lords, that in this case they are proceeding under 61, but the SMT 10 is absent, and therefore the other steps thereafter all have effectively not transpired. And as a result, they have gone straight to 73, and we are saying that that is something which is clearly unsustainable in the law. May I now go to the Rajasthan judge? My lords have that. May I just give a short summary so it will place it in context. My lords, in this situation, there is a proceeding under section 61 for a discrepancy. They did issue the ASMT 10. So here the facts were better. Whereas in my case, there is admittedly no ASMT 10. An explanation was provided by the assessee. Without taking cognizance of that explanation, they issued a section 73. And after issuing a 73, they also issued a ASMT 12 saying, I find your explanation satisfactory. Now, in these facts, the Rajasthan High Court examined it. First to say that if you invoke 61, the whole procedure of 61 is mandatory. That if you don't follow 61, then your 73 is effectively bad. Now, in this case, they passed an order on the 73. So the writ challenged the 73 notice and the subsequent order. The Honorable High Court sets aside both of them. I'll just take my lord's. The petition is directed against the order of 29/9/23. My lord, have that. On the first page, para 2, my lord.
No, you take us to the specific paragraphs, the reasoning.
Yes, my lord. Would my lords please come to paragraph 15?
Yes.
That is where the section is set out. May I now read 16? Subsection 1 of 61 authorizes the proper officer to scrutinize the return and related particulars and inform him of the discrepancies noticed, if any, in the prescribed manner and seek his explanation thereto. Subsection 2 and 3 deal with different contingencies. Subsection 2 provides for a course of action that may be adopted in a case where the explanation is found acceptable. Subsection 3 deals with the procedure to be followed in case in which no satisfactory explanation is furnished within a stipulated period. 17. A fair logical construction and interpretation of the aforesaid provision would mean that once the proper officer undertakes scrutiny of return and comes across any discrepancies in the said return, he may seek explanation. Where explanation is found acceptable, the registered person is required to be informed accordingly. No further action is to be taken in this regard. It is only, my lords may notice the word only, it is only when no satisfactory explanation is furnished within the stipulated period or where discrepancy having been accepted, corrective measures are not taken, that the proper officer assumes jurisdiction to initiate appropriate proceedings under 65, 66, 67 or for the collection of dues under section 73 or 74. So it says it is only then that can we go to 73. In the present case, once the notice under 61 was issued to the petitioner, requiring its explanation pointing out certain discrepancies, the proper officer, before he could assume jurisdiction to issue notice under 73, was mandated under the law to consider the explanation offered by the petitioner. So, my lords, here they gave notice, he gave explanation. But they again reiterate. First, they say only if you follow the process, you can go to 73. And again, they say that if explanation is given, you have to consider before you go to 73. Then, my lord, would come to para 23, which is the counter of the department. The submission of the learned counsel for the respondent, my lord, have that.
Yes.
That the power under 73 could be invoked irrespective of whether there is satisfaction in terms of section 63(1) was arrived at or not is misplaced both in law and on fact. Where a show cause notice is based on the discrepancies found in the return, like I showed my lord in our case. Where the show cause notice is based on discrepancies found in the return and not on any other independent material, the proper officer is obliged under law to follow the mandate of section 61 before invoking jurisdiction under section 73. Present is not a case that on any other material the proceedings under section 73 were initiated. Present is on fact the case where jurisdiction under 73 has been invoked and show cause notice has been issued on the basis of the discrepancies found in the return. If that be so, jurisdiction under 73 could be invoked only after complying with the mandate of 61 and not otherwise. My lords have that. And my lord, I had shown my notice is only based on a 61 scrutiny. My lords, if we go, there is a judgment which was cited, Nagarjun, which said that a notice under 74 and a 61 are distinct, Allahabad High Court. That is distinguished by Rajasthan to say that there was other material, not just the discrepancy under 61. There being other material, effectively, there could be a proceeding under 74. So that they distinguished. And now if we come to para 24, at the cost of reiteration, we notice that the present is not a case where jurisdiction under 73 has been assumed on grounds other than the discrepancies found in the return. In the present case, the invocation of jurisdiction under 73 is based on discrepancies found in the return. If that be so, the mandate of 61 is required to be followed by the proper officer before assuming jurisdiction under 73. And my lords, based on all of these findings, please come to 29. In view of the above, the show cause notice issued to the petitioner is found against the provisions contained in 61. Resultantly, the show cause as well as the assumption of power under ASMT 12 are both declared illegal and unsustainable in law and therefore set aside. My lords have that. My lords, this goes up to the Honorable Supreme Court as a departmental appeal, and the Honorable Supreme Court says they are not inclined to interfere. Now, my lord, everything in this Rajasthan judgment, my lord, is pivoted on the fact that the entire proceeding is a 61 proceeding on discrepancy, nothing else. May I just, in conclusion on this point, my lord, show the notice at 54. It is only based on the discrepancy under section 61. Para 54.
Oh.
Sorry, page 54, my lords, of my writ petition, the impugned show cause notice. Page 54, para 2. My lords have that annexed to 2. Please see para 2. Whereas it appears as per section 61, so it's a 61 proceeding and nothing else. And the discrepancy is claimed to be between my GSTR 9 and GSTR 9C. My lords, over the page also they cite section 61 in its entirety. And at page 56, para 4 also, the whole cause of action is, whereas it appears that from form GSTR 9 and 9C were available, it cannot be construed that there was any fraud. Therefore, proceedings for recovery has to be initiated under 73. So it is the 61 scrutiny which is the sole cause of action for the 73 notice. My lords, our first challenge is therefore, my lord, that the 73 notice in this case is bad in its inception because the compliance with 61, section 61 and rule 99, which should have preceded, which were prescribed jurisdictional preconditions and jurisdictional facts, not being complied with, my lords, the entirety of this notice must effectively go. My lords, there is a second argument on the aspect of the discrepancy itself. My lords will permit, I'll just take a few minutes. My lord, under 61, the so-called discrepancy is that I have filed a form, which is my GSTR 9. Now, this GSTR 9, as I file it, has certain details, including details about the input tax credit which I have taken. The GSTR 9, my lord, is a reflection of my various returns and records for the purposes of GST. They also prescribe that based on my books of accounts, I should file another form, which is GSTR 9C. And then they say that these two forms, we effectively will compare. And if we find a discrepancy, then the whole process under 61 and Rule 99 has to be followed. Now, my lords, when they initially prescribed these particular forms, they prescribed in the context of GSTR 9C a table 14 and a table 12. Would my lords please take my compilation? May I call attention, my lords, to page 5 of my compilation. My lords, I have that. My lords, this is the form GSTR 9. I'm just showing it statistically. Please now see at page 42, the GSTR 9C. I don't need to take my lords to any details in 9. Please come to page 42. My lords have that. My lords, this is the prescription of the form GSTR 9C. There is here, my lord, two tables which are of relevance, which are to be found at page 47. On top of page 47, my lord, would my lord see there is a table 12. It says reconciliation of net input tax credit. My lords have that. Now, my lords, please see items D, E, and F over here. May I just read D? ITC, that is input tax credit, availed as per my audited financial statements. E is input tax credit which is claimed in my annual return, which is my GSTR 9. And F is whatever may be unreconciled, or the difference between D and E. And then at 13, I can offer an explanation. Now, my lords, D and E, in a manner, are a sum total of D is a sum total of my ITC as claimed in my audited financial statements, and E is the sum total of my ITC claimed in my annual return. Now, D is further itemized at table 14. Please see 14 in the same page down. My lords have that. Reconciliation of ITC declared in the annual return GSTR 9 with ITC availed on expenses as per the audited financial statements. Now, my lords, here in my audited financial statement, my expenses are broken up item wise. So, my lords will see, for example, A is my purchases, B is my freight, then power and fuel, then imported goods. So, all that 14 does is it breaks up what is set out in 12D. Now, my lords, if you come over the page, my lords, and please come to 49. My lords, have 49. Please see item R. It says total amount of eligible ITC availed, ITC claimed in the annual return, which is GSTR 9. And then again, it says unreconciled ITC. That item T, which is there, is the same actually as item F in table 12, namely unreconciled ITC. It's the same number. It should be. Now, my lords, what happened is that this table 14, because it was getting very complex and people were just coming into GST, this table 14, they actually made it optional. They said you don't need to file this. May I just go to that notification? That notification is at page 110
of your compilation.
of my compilation. At 110, the notification begins. My lords have that. 14th November 2019, my lords, they make an amendment to the rules. So they say, in exercise of the powers under section 164, the central government hereby makes the following rules further to amend the CGST Service Act rules of 2017. And they say that these are the amendment rules of 2019. Please come to page 116. My lords, in 116, towards the middle of the page, would my lord see the subpoint capital C? My lords have capital C. it says again serial number 14. The entry ending with the words are to be hereby declared. The following entry shall be inserted, namely, for the financial year 17, 18, 18, 19, the registered person shall have an option not to fill this table. My lords, have that. So they gave an option not to fill table 14. And this option, my lords, has continued till 2023. So that filling of table 14 has never been seen as being relevant. Can I just show, my lord, page 59? I'll just show that till,
This is for which period?
my lord,
The assessment?
my 1780. And my lords have seen at 116 that for 1718 it's made optional. But may I just show that till 23 it's optional? Would my lords please take page 59 of my compilation, and I want to call attention to page 71, showing you that this optionality has gone on.
Yeah.
Would my lords come to 71?
Yeah.
My lord sees 14, table 14 on that page to the left. My lord has 14 after 13 at page 71, my lord.
Yeah.
The last sentence is that for financial years 17, 18, 18, 19 till 22, 23, the registered person shall have option to not fill this table. My lords have that. Therefore, my lord, in the statutory scheme and in the procedural scheme, 14 actually became irrelevant if you opted not to fill it. Now, in our case, we opted not to fill it. So how does the controversy arise in our case, my lords, is because I didn't fill it, some parts of the software of the department, they automatically total certain items. So in my case, while I put everything as 0, they totaled it to a certain amount, and that amount as totaled by their software, they're saying that is effectively your discrepancy. May I just show that? Would my lords please see my petition? And would my lords please come to page 121 of my petition?
Yeah.
My lords will see, this is my form GSTR 9C. My lords have it. And my lords will see that the financial year is 2017-18. My lords have that.
Yeah.
My lords have seen that. May I invite my lords to please see page 125. First, I'll just show table 12 and then I'll show table 14. My lord sees at page 125, table 12 under point Roman 4. Please see item D. ITC availed as per the audited financial statement of books of accounts. My lords have that. 19.49 crore. Please see E. ITC claimed in my annual returns GSTR 9, 19 crore 51. My lords have that. If you see F, therefore, it says that the unreconciled ITC is 2 lakhs of rupees. My lords have seen that. And then I give the reason why it is in table 13 that the difference pertains to Tran 2 credit. Means when I was transitioning my old service tax credits to GST, there one entry was late. Therefore, there is a difference of 2 lakhs. Now, my lord sees at 14, I have exercised the option not to fill any figure. My lords have seen that. Everywhere I have put 0. My lord sees that.
Yes.
Now, A to R, therefore, I put 0. My lords have seen that. At S, the software of the department picks up the number of what credit I had claimed in my return, which is 1951. My lord sees S, ITC claimed in annual return.
That's the
It
figure
pick-
at E.
Correct. Absolutely. I'm very grateful. The figure E they transpose. And as a result, they say that my whole unreconciled ITC on the next page is 1951. And that 1951 is the demand in this case.
Instead of 2 lakh.
Instead of 2 lakhs, and that 2 lakhs I have paid. So that 2 lakhs is also not contention. So my lord, the issue therefore is 61 is triggered on a discrepancy. My lords have seen that. If we see section 61 at page 93 of my compilation, or if my lords are seeing the petition, please see page 164 in the petition.
Yeah. Yeah.
May I just read that? The proper officer may scrutinize the return and the related particulars furnished by the registered person to verify the correctness of the return and inform him of the discrepancies noticed. Therefore, my lords, there must be a discrepancy. Now, when filling in certain returns or information is made optional by law, and I exercise the option not to fill in the details, my lord, then there is a situation where there can be no question of a discrepancy, because if you look at my annual return, you have that. But if you look at my 9C, I have said 0. So now there is no question of there being a divergence or discrepancy. If I have to fill form A and form B, I fill both. There is then some situation where they don't reconcile. Yes, there is a discrepancy. But if I don't need to fill form B at all, then in law there can never arise a discrepancy, because there was never an obligation in the law to fill that table 14 at all. So, my lord, we are saying the other jurisdictional defect is that when table 14 is optional, there can arise no discrepancy from exercising the option not to fill table 14. And my lords, the term discrepancy is not defined in the Act, but at our petition at page 28, my lord, we've taken the relevant definitions from the dictionaries. And of course, we all understand the term, but the dictionary definition is a difference between two things that should be the same. Now, when that second thing does not exist, because in law I have no obligation to fill it, I have an option not to fill it, I therefore don't fill it, then there can be no comparative between one and the other such that a discrepancy can arise. So, my lords, that's our second point in relation, my lords, to this. My lords, in conclusion, may I just show one judgment of the Honorable Supreme Court. It's a very terse and well-stated proposition in the law. It is in my compilation at page 159.
Agar.
My lord, at 159, Bhavnagar University. My lord, that was the issue under land acquisition. But the proposition of law is terse at 173, para 40, my lord. May I read, my lord, para 40, second line onwards. It is well settled that when a statutory authority is required to do a thing in a particular manner, the same must be done in that manner or not at all. Sorry, my lord, I have that.
Yes, yes, carry on.
The state and other authorities, while acting under the said act, are only creatures of statute. They must act within the four corners thereof. Now, my lords, here I am faulting them on two grounds. They could have never gone to 73 without exhausting what is prescribed under Section 61 and Rule 99. The second is, when the rules are amended to make the filing of Table 14 optional, they have ignored that. In fact, if my lord sees their affidavit, at three places they say filing Table 14 is mandatory. Please come to their affidavit, running page 179. May I call attention to page 182, para 7.
Yeah.
Would my lord at para 7 please see the last three lines to the right? The furnishing of information under Table 14 of GSTR 9C was mandatory. My lord, this is directly contrary to the amendment to the rule, which started in 1718 and has gone on till 2220. This is repeated at page 185, my lords, para 16. My lords have
Yes.
para 16.
Yes.
With regard to para 14, the answering respondent states that the petitioner failed to furnish information which was mandatorily required under Table 14. There is no mandate. In fact, it's to the contrary. And my lords, that is again repeated at page 86 at para 21 in the last sentence. The furnishing of the information under Table 14 of GSTR 9C was mandatory. My lords, I have that. So, my lords, we are saying that the notice under 73 is contrary to mandate of law. The position that there is a discrepancy which results in a cause of action because filling 14 is mandatory is also contrary to the mandate of the law. My lords, on both of these, we crave the reliefs that we have prayed for. I'm very grateful.
Just one question.
Yes,
All these you can urge before the statutory authority, including lack of jurisdiction.
my lord,
Why?
only
Why are
this. That as
Is
we,
it only because of the pre-deposit?
no, my lord, not because of the pre-deposit. Let me explain this. Two things have effectively happened. Firstly, let me just explain that this proceeding is in isolation. This is only come for 1718. Even in later years, we have filed similar returns. There are no proceedings.
We accept your argument.
Yes, ma'am.
Even if we accept your argument,
Yes, ma'am.
if you're claiming submit to the statute, you can go and file an appeal and point out that therefore subsequent
My lord, my lords are right. So my lords are taking me back to why would I not take the alternate remedy? Why would I come? Yes, which is dealt with in the interim order. And what is dealt with in the interim order, and I'll just take my lords there, is that the issue that we bring here is not a disputed question of fact in any manner. It is not disputed, there is no SMT 10. The issue is clearly a complete lack of jurisdiction. Now, the aspect of a lack of jurisdiction, namely that he could have never entered upon the Section 73 proceeding without exhausting what was required under 61 and 99. That issue of jurisdiction, my lord, squarely falls before my lord, because he is not in a position to decide his jurisdiction. He has embarked upon his jurisdiction.
Not he. I'm talking about the higher appellate authority.
No, my lord.
Anyway, we'll examine that.
My lords, here the situation is, we have come at the stage of show cause. My lords would see, even in terms of the Supreme Court, and may I just show two things, my lord. One, may I go back to the interim order here,
Yes.
but may I also show the Supreme Court judgment in Godrej Sarali, where they've said that if you fall in the four circumstances, one of which is breach of natural justice. The second is a complete lack of jurisdiction. Then it is within the domain of the writ court to effectively entertain. Now, my lords, that when it came up before this court and this objection was taken at that stage, may I just go back to that order of
No,
1312?
we are aware of that,
Yes, ma'am.
but that is at the instance of, that's an interim order at the stage
Yeah.
of granting you,
My lord, may I show
granting
Godrej
you
Tara
an
Lee?
interim order. We are only asking you,
Yes,
would be your argument besides say Godrej Tara Lee or the other judgment? Appeal. What is that?
my lords, we relied on Whirlpool. We also, my lords, effectively relied upon Harmallah Sahni. And my lords, we effectively relied on the factor of showing in Magad Sugar that
No,
where
there any authority or time that besides the there are, you're right that there is a question of jurisdiction which the Supreme Court has embarked up not the act. But either it require actual
my lord,
evaluation and the records are available to the authority. Whether this whether there were any other materials that are on it, whether the ground which the authority should have or not to have invoked it are also issues that can be looked by.
my lords, may I only make this point? And I'll answer in three ways. One is, my lords, the situation where there is a clear lack of jurisdiction, as opposed to where there is a jurisdiction and the issue is it rightly or wrongly exercised? The courts have made a distinction between where there is a lack of jurisdiction and where the officer enters upon the jurisdiction rightly, but effectively having entered jurisdiction, he then has to decide in which manner he will determine the matter. And I'll just show two judgments. One is Godrej Tara Lee, and I'll show Godrej and Boyce Justice Datta's judgment in Bombay High Court, where he says that at the point of assumption of jurisdiction, if there is a legal flaw, then the writ court must step in and effectively deal with it. And in that case, he sets aside a show cause notice. So one is the distinction between a complete lack of jurisdiction and jurisdiction wrongly exercised. That one distinction. Now, if we see, my lord, the judgment in Godrej Tara Lee, and it's in my compilation at 142. Now, in this case, my lord, the High Court refused to interfere. My lord, I have 143. I read paragraph. This appeal by special leave registers a challenge to an order of 12th October 2009 by the High Court of Punjab and Haryana, dismissing a civil writ petition and relegating it to the remedy of an appeal. My lord, I have that. Two questions emerge: whether the High Court was justified in declining to interfere on the ground of availability of alternate remedy, and whether we should remit the matter to the High Court for hearing on merits to examine the correctness of the orders impugned before the High Court.
Yeah.
Now, my lords will see, they, in this particular case, make out the distinction between that which is entertainable and that which is maintainable. My lords have seen that. May I just point that out? This is at page 144. My lord, I have that.
Yeah.
May I just read? In a long, I read at the top of the page. In a long line of decision, this court has made it clear that the availability of an alternate remedy does not operate as an absolute bar to the maintainability of a writ petition, and that the rule which requires a party to pursue the alternate remedy by statute is a rule of policy, convenience, and discretion rather than the rule of law. Though elementary, it needs to be restated that entertainability and maintainability of a writ are distinct concepts. This is fine, but real distinction between the two ought not to be lost sight of. The objection as to maintainability goes to the root of the matter, and if such objection were to be found of substance, the court would be rendered incapable of receiving the list for adjudication. On the other hand,
Yes.
the question of entertainability is entirely within the realm of the discretion of the High Court, writ remedy being discretionary. A writ petition, despite being maintainable, may not be entertained by the High Court for very many reasons, or relief could even be refused, despite setting up a sound legal point, if the grant of claim of relief would not further public interest. Here, dismissal of a writ petition by a High Court on the ground that the petitioner has not availed alternate remedy, however, without examining whether an exceptional case has been made out, would not be proper. Then, my lord, they refer to Muhammad Noor, and effectively para 6, they say at the end of the last century, this court in paragraph 15, in the decision reported in Whirlpool, my lord, I have that. My lord, I am reading at 145.
Yes, carry on.
Carved out the exceptions on the existence whereof a writ petition would be justified in entertaining, whereof a writ court would be justified in entertaining a writ petition, despite the party approaching it not having availed the alternate remedy provided by statute, the same read as under. My lord, serial number 2 is relevant, where there is a violation of natural justice.
Yeah.
And 3, where the order of proceedings are wholly without jurisdiction. 7, not so long ago, this court, in its decision reported in Assistant Commissioner versus Commercial Steel, has reiterated the same principle in paragraph 11. That apart, we may also usefully refer to the decisions of this court referred to in Indian Hume Pipe and in State of Haryana versus Union of India. What appears on a plain reading of the former decision, that whether a certain item falls within the entry in a sales tax statute raises a pure question of law, and if investigations into facts is unnecessary, the High Court could entertain a writ in its discretion, even though the alternate remedy was availed. And unless discretion is shown to be unreasonable or perverse, this court would not interfere. In the latter decision, this court found the issue raised by the appellant to be pristinely legal, requiring determination by the High Court without putting the appellant to the mill of statutory appeals in the hierarchy. What follows from the said decision is that where the controversy is a purely legal one, and it does not involve disputed questions of fact, but only questions of law, then it should be decided by the High Court. My lords have seen. Then it should be decided by the High Court instead of dismissing the writ petition on the ground of an alternate remedy applicable. And my lords, in this case, then they set aside the High Court order, which said it won't interfere, and effectively
Para 38, whatever. Up. What will be put?
yes, my lord, a decision may be questioned as suffering from an illegality if its maker fails to understand the law that regulates his decision-making power correctly, or if he fails to give effect to any law that holds the field and bind the other party. On the other hand, having regarded that the purpose of Section 64 seeks to serve to take exception to a decision on the ground of propriety or any proceeding or order in such proceeding, it is essentially ought to relate to a procedural impropriety. Yes, ma'am. And here we are saying it's a complete lack of jurisdiction. May I just show one line from the Godrej and Boyce Bombay High Court, where he says that upon the assumption of jurisdiction if there is a fatality. May I just hand over one more compilation? This has the Godrej.
The High Court judge.
Yes. It's not in this compilation. I'm just.
Yeah.
My lords, in this case also they came at the show cause. All the grounds on alternate remedy was set up. And I'll just go, my lord, to my lord would see 14, para 14. Sorry, my lords have that. At page 39, para 14.
Set aside by the same author.
Sorry?
Is it the same matter which traveled to the Supreme Court?
No, my lord. Different. Godrej Sarali, Godrej and Boyce. But here, for the reasons as aforesaid, we hold the present case is one where the impugned show cause notice suffers from an error going to the root of the jurisdiction of the respondent in assuming jurisdiction and is accordingly indefensible and liable to sentence. My lords have seen that para 14, page 39.
Yes.
So here they make a point that lack of jurisdiction at the point of assumption of jurisdiction. If that is not there, then my lords, he has no status in the law to hear me or to proceed with the matter. If he has no status in the law to hear me or proceed in the matter, then going before him is just an empty formality because I am giving or vesting jurisdiction in someone who does not have it. Which is why, if there is a patent lack of jurisdiction at the point of assuming jurisdiction, then they say it is indefensible, then the writ and therefore the setting aside. And my lords, notice that also in Rajasthan. Rajasthan is a case of 61. Rajasthan is a case of a show cause. There is a ASMT 10, there is a reply. Then there is a section 73 notice. What is set aside by Rajasthan is the section 73 notice, saying that once you have not followed section 61, your 73 notice itself goes. May I just show that to my lord?
Yeah.
Would my lord see, para 2, there is an order of 29/9/23. Then, my lords, there is a ASMT 10, which was issued. And para 6, they say that they issued a notice under section 73, which is of 21/9/23. My lords have para 6. Finally, what is set aside, my lords, at para 29 is the show cause notice issued to the petitioner is found against the provisions contained in 61. Resultantly, the show cause notice, as well as the assumption of power under the enclosure of ASMT 12, both are declared illegal and unsustainable. So, my lords, where 61 is not followed, the resultant 73 is the assumption of jurisdiction without authority. That wrongful assumption effectively renders it illegal, going before the officer who has no jurisdiction. Because for me to go and appeal, first I have to go to him. And may I also mention, my lord, there are time limits prescribed for them to act. For him to have validly acted under 73, even today, if he had to issue the ASMT 10 and then go to 73, that period, my lords, ended in the September of 23. So therefore, today, there is no ability to recreate any proceeding that go to ASMT 10, let him then come to 73, because that period statutorily has passed. My lords, our submission is all doors are closed. This, as it stands, is unsustainable in the law. I'm grateful.
if what I understand from the submission of my learned senior friend, that some provision has not been followed. That doesn't mean that the notice was not issued by the proper officer. Let's say we come to page 54. Page 54 into notice.
Yes.
In my humble opinion, there is no question of lack of jurisdiction. Let's say the authority who issued the notice has a proper jurisdiction and the proper authority to issue notice. Let's say we come to page 54. Notice dated 5/9/2023. Lordship, please to note that the Stogos notice was issued on the date for 5 dates. Filing reply, Lordship, page 80, 180 of my affidavit, paragraph 3.
Yes.
Paragraph 3, with regard to the averments made in paragraph 1, the respondent states that the PepsiCo India Limited, herein the petitioner, was given 5 opportunities on 22/9/23, 6/11/23, 15/11/23, 1/12/23, and 11/12/23 by adjudicating authority for
So
personal
this
in
is
respect of
after issuance of the show cause.
Lordship. Yes,
This is after issuance of the show.
yes, so after
There
issue,
is no dispute that as required under 61, the notice under
yes, Lordship,
10,
that is
that was
we have
not issued.
admitted in paragraph 19, but continued by learned
And-
senior.
Your argument perhaps would be that even without following that procedure, you can adopt 73.
Yes, Lordship, that is my submission. And Lordship, the case is at the stage of filing reply, Lordship. Not has been, final order has been passed by any authority. So the submission of my learned senior friend that the notice is without jurisdiction and the person who has issued the notice has lack of jurisdiction. That is, in my humble submission, this is not correct. And Lordship, in notice may come to paragraph 1, Lordship. Whereas it appears that PepsiCo India Holding Limited, so and so,
Para 1 of
page 54, Soco's notice, demand subcon notice. The allegation is that has wrongly availed input tax credit amounting to rupees 90 crore 51 lakhs so and so. Then paragraph 2. Whereas it appears that as per section 61 of the CGST Act, GSTR 9 and GSTR 9C return related to the financial year 17/18 were taken up for scrutiny. While analyzing GSTR 9 and GSTR 9C for the financial year 17/18, had the data available to review the extent of identification mismatch in ITC declared in the annual return with the expenses reported in the financial statement. The officer of the Director General of Audit, Calcutta, has observed that the notice has unreconciled ITC of rupees 19 crore 51 lakhs and so, including so, as detailed below. Then detail has been given. The above deviation resulted in non-payment of tax of 19.51 crore, and this was ascertained during subject specific compliance audit conducted by the Director General Audit so and so. Then paragraph 3, where it appears that table 14 of the form GSTR 9C with the expenses incurred by the taxpayer that that can be formed of input capital goods or services. These goods services procured may be taxable or exempted and may be procured from registered forward charges or unregistered reverse charges. Table number 14. Reconcile the expenses incurred with the ITC avail and any excess availing on account of ineligibility block credits composition schemes. The statutory provision has been quoted. Then let's say we come to paragraph 4, page 56, where it appears that as both the form GSTR 9 and GSTR 9C were available in GST backed system for scrutiny, it cannot be constituted that there was any fraud, willful misstatement or suppression of fact in the instant case. Therefore, proceeding for recovery of the ineligible tax credit has to be initiated under section 17 of GST Act, as section 74 relates to ITC wrongly availed due to fraud, will misrepresentation and suppression of facts. Then 73 has been quoted. Then let's say come to paragraph 5, whereas it appears that there is an unreconciled ITC amounting to rupees so and so, as reflected in GST and 9C, the notice for the financial year 17-18, the said notice is liable to reverse the wrongly availed and unutilized tax credit amounting to be so and so, along with the applicable interest so and so so and so. Then it's paragraph 6. Now therefore, Messrs. PepsiCo India Holding Limited so and so is hereby called upon to show cause to the Additional Commissioner of Central GST and Central Excise Guwahati so and so within 50 days receipt of this notice. Then Lordship note was so nothing can be decided. And Lordship, I am relying on one judgment of Allahabad High Court, Division Bench 40. Is Division Bench of Allahabad High Court. Paragraph 2. The SEC is the petitioner is an SEC under GST regime and has submitted return for the assessment year 2018-19. The department apparently has not initiated any action referable to Section 61 of the Act. It transpired that the proceeding under Section 70 have been initiated by the department against the petitioner on certain ground with regard to classification and consequential tax payable of certain goods. The department has examined issue and ultimately pass an order impugned whereby the tax previously paid was found short and the demand has been raised for deposit of the appropriate shortfall in the deposit of the tax and so. Then Lordship, Section 61 is quoted. Lordship, we come to paragraph 5. Section 61 regulates scrutiny of the returns. In the process, the scrutiny of such return, the proper officer has been vested the jurisdiction to examine the return and in case any discrepancy are noticed therein, the professor can intimate such discrepancy to the SSC with the object of conferring an opportunity upon the SSC to rectify the discrepancy. The discrepancy may be different kind. The proper officer is also vested with the jurisdiction under Section 61 to proceed with the issuance of the notice against the SSC with the deficiency pointed out by the department in not rectified and no satisfactory explanation is furnished in that regard. The exigency which dealt with under Section 61 is therefore quite distinct and confined to the scrutiny of the returns. Then paragraph 6. In the present case, it does not appear that the discrepancy was noticed by the department in the return of the petitioner, nor any such discrepancy was pointed out to the SSC for it rectified by it. The returns therefore remains intact. In the later stage, the consideration of the return, the department has found that the proper officer has not been deposited, the proper tax has not been deposited, and consequently proceeding under Section 74 has been initiated and concluded against the petitioner. In the statutory scheme, the court followed by the department would clearly permissible in law. The argument that unless deficiency in the return is pointed out, the SEC an opportunity is given to rectify the deficiency, the department can proceed under Section 74 is not borne out in the statutory scheme, and the argument in this regard therefore must fail. The scrutiny proceeding of returns as well as the proceeding under Section 70 are two separate and distinct exigencies, and issuance of notice under Section 61(3) therefore cannot be constituted as condition precedent for initiation of action under Section 74 of the Act. It is so far as judgment relied by the counsel for the petitioner in the case of Vidhival Protect so and so, we find that the observation of the learned single judge of Madras High Court therein, the fact that the case and do not lay down any proposition of law which restricts the jurisdiction of under Section 74 upon issuance of notice under Section 61(3) of the Act. In our view, the merely because no notice were issued under Section 61 of the Act would mean that the issue of classification or short payment of tax cannot be dealt with under Section 74 as exercise of such power is not dependent upon issuance of notice under Section 61. The argument is misconceived.
In case of the Rajasthan judge, they have just placed.
Lordship, this is again a judgment of the Allahabad High Court of
No,
Division.
this Rajasthan judgment has been affirmed by the affirmed in a sense that the
It
SLP
was-
was,
Yes, SLP were dismissed. So Lordship, there is a distinction between the proposition of law as held by different high courts. Because here in Allahabad High Court,
no, here, as the case projected by the petitioner, that the only ground
that
for issuance of PROCOS
focus was not.
is the discrepancy which you have noticed in terms of the ITC stated to have been wrongly available. Now, the procedure according to them prescribed under 61, if it was followed, perhaps they could have clarified and matter could have ended there.
Lordship, in my
My lord, my learned can point out that Rajasthan has specifically distinguished Allahabad. At para 23, Rajasthan has specifically distinguished Allahabad. May I just show that?
Nagar,
Yes, ma'am. May I come to that? For that reason, reliance placed on the decision of the division bench of Allahabad High Court in case of Nagarjuna is completely misplaced, being distinguishable on the fact that that was not a case where the proceeding under 73 was initiated on the basis of scrutiny of return. The department had not initiated any action referable to section 61. But independent of that, and so on certain grounds with regard to classification and consequential tax payment payable on certain other goods. The question which arose for consideration was whether the department is enjoined to issue a notice under subsection 3 of 61 once returns have been submitted by the assessee before initiating action under 74 or not. While deciding the said issue, it was held that the scrutiny proceedings of return as well as proceedings under 74 are two separate and distinct exigencies, and therefore issue of notice under 61(3) cannot be construed as a condition precedent for initiation of action under 74. At the cost of reiteration, we notice that the present is not a case where jurisdiction under 73 has been assumed on ground other than discrepancies found in the return. In the present case, the invocation of jurisdiction under 73 is based on discrepancies found in the return, which I am grateful my learned friend read the show cause fully because it is only on discrepancy in return. If that be so, the mandate of 61 is required to be followed by the proper officer before assuming jurisdiction under 73. This point is fully dealt with. That has gone to Supreme Court.
if another judgment of Gujarat High Court is on
Can we-
61. I'll provide 5 minutes. Just I find out just now. But if in this case, in paragraph 19,
Can we have the
2024-0 Supreme Gujarat 2142.
there,
No, actually, Lordship, I just find out recently, and I have taken a copy from the court martial record.
here, like,
I'll-
but second,
Look.
you want
Yes, man. Otherwise, let him argue it.
Provide copy, Lord. Considering the paragraph 19, considering the above submission, impugned summary order dated 11/1/2019 is required to be passed and set aside, and the same is passed without there being any notice issued in form TRC 1 as provided under the GST rule. Admittedly, the facts of the case respondent authority did not serve any so-called notice on the petitioner and straightway issued impugned form in form GST TRC 7, which does not contain regions. Therefore, without going into the merit of the matters, the impugned summary order
know what we're
In-
trying to
Lordship,
do.
matter
that
may be
in view of judgment of the Rajasthan High
Lordship.
Court, the SLP has dismissed, it has helped.
But Lordship, on merit, it was not considered by the Honorable Supreme Court.
It would be, but
And Lordship, here the main contention of the petitioner is that some provision of section 61 and rule were not followed. And Lordship, admittedly, by impugned order, the proceeding was kept in
the
abeyance.
focus notice prima facie shows that this was the only ground.
Here, this is the only ground by taken by the
So
land.
you show us from any judgment that even if there is some discrepancy in the return file, you can take recourse to 74 without
No, no,
first giving
here we have admitted that section 74 is
SMT 10.
SMT 10 was not issued. That is admitted. So that can be cured, Lordship, because the landed senior has submitted that the period has already been lapsed. But during this period, the entire proceeding was put under stay. So we'll get the benefit of that. We can issue now, Lordship, as observed by the Honorable Gujarat High Court in paragraph
Now what?
that we can TRC 10, Lord.
So you'll have to withdraw the
Yes, definitely, Lordship, Lordship, that because the proceeding has kept under the stay for during this period, last more than 2 years. Lord. So the period will be detected from that period, Lord.
come up with the
No, my lord, the proposition is completely unstateable. May I just make good why? My lord will please see, if my lord sees my compilation, please see page 141 of my compilation.
yes.
Lord, there is a time limit prescribed under section 73 for the adjudication. That is under 73(9) and 10. Now, by this notification, my lord, which is 31st March 23, the time limit for adjudication for the financial year 17-18 was extended to 31st day of December 23. My lords have that. Now, my lords, please see section 73 at page 96. Would my lords please see 73(2). The proper officer shall issue the notice under subsection 1 at least 3 months prior to the time limit specified in subsection 10. So the time limit in subsection 10 is extended to 31/12/23. Therefore, this should be now issued before 30th September 23. Now, my lords, the interim order which he is trying to rely on is passed on 13/12/23. Therefore, the interim order came to be passed. My lords have that.
Yes.
It is passed on 13/12/23
Where is that extension notification?
at 141.
Yes.
My lord, that extension for the financial year in question, which is 17-18, is up to 31st December 23. My lords, I have noticed that.
Yes.
I have to have issued the notice 3 months before. That is, they should have issued it by 39/23. The interim order he relies on is an interim order of 13/12/23. So that has not stopped his time. He had effectively lost his time on 30th September 23. Now, what is he saying? I will go back to ASMT 10. What is the purpose of ASMT 10? Either there is resolution or it culminates in 73. But if it has to culminate in 73, the power should have been exercised before 30th September 23, which is why we are saying all doors are closed. We have completely missed the bus. My lord, he should have issued the notice under 73 by 30th September 23. The order, which is the interim order, is of the 13th of December 23. So he is claiming the benefit of section 75, saying if there is a stay, the period for issuance of notice stops running. But his period had run out on 30th September 23, much before this order. So neither this order nor section 75 come to his rescue. Therefore, today there is no way to reinvent this proceeding, saying I'll go back to ASMT 10.
What?
Sorry?
What about what?
Yes, my lord.
The time?
There is no time limit in that manner. My lords, there is, I'm sorry. There are actually 30-day periods prescribed. Yeah, please see 93. My lords have got that.
Yeah.
So if we first see (99)(1) has a period, my lords, of 30 days.
So that is the seeking explanation.
For seeking explanation. Now, if my lords was to see this, so first is shall issue a notice informing him seeking his explanation within such time not exceeding 30 days. Then, my lord, either I accept or I give an explanation. Then, my lord, under 61(3), if no satisfactory explanation is given within a period of 30 days, then he proceeds to 73. Now, if my lord sees the SOP, if I might just go back to the SOP, my lord. Annexure 10, my lord. In the writ petition at 166, may I call attention to 170, my lord?
Yes.
Please see serial number 5. Issuance of notice by the proper officer for intimating discrepancy in form GST ASMT 10 within the month as mentioned in the scrutiny schedule for scrutiny of the returns of the said GSTI.
So it's the same thing.
Oh, my lord.
Issuance of notice
Yes,
by the proper officer, intimating the discrepancy.
yes. The period prescribed, my lords, on the right.
Is it the period prescribed for the notice or period prescribed for the reply?
No, my lord.
Explanation.
Issuing of notice. Reply is the next item. My lord has the next item, reply.
That is also within 1 month.
That's right. So, my lords, the procedure is very, very
So
clearly laid
in
out.
your case, it should have been issued when? Assuming 61 was invoked.
My lord, if it was invoked, when there was a time period within which he had to take up the scrutiny. Within 30 days of his taking up the scrutiny, he should have issued it. Within a further 30 days, I should have replied.
Is there any date available when it was taken up for scrutiny?
My lords, we don't have a, but may I only put this proposition in Bhatinda Cooperative, that if there is no time limit prescribed, it has to be seen consistent with the time limit specified in the rest of the statute. And the rest of the statute here, relevant to 61, is talking of an alacrity, saying your reply must also come within 30 days. The standard, the procedure prescribed says 30 days. We obviously cannot give it a greater latitude than that.
All right.
Yeah, and ultimately, what is the ultimate destination if they have to culminate their case? 61 has to go to 73. If 73 is now, the date is passed, then nothing remains. All this then is pedantic. A grateful man.
But in paragraph 19, we have stated,
Paragraph
paragraph 19 of my affidavit,
13.
19,
Nine.
page 186.
What?
19, page 186.
Yes.
That with regard to the state averments made in paragraph 17 of the writ petition, the answering respondent stated that non-issuance of SMT 10 does not violate the basic principle. Now, Lordship, may please to see what is the form SCM 10, Lordship. We have to point out the discrepancies that has been pointed out in our notice also, Lord. And Lordship, furthermore, they have took 5 adjournments for filing reply.
Their primary without one. And but
His lordship,
Discrepancy, follow the,
no, yeah, that is their lordship.
and
But-
you admit that the procedure was not 74,
73,
73,
73 one, because there is no,
on the ground of, there are no other materials, such as fraud
no,
or
that
pressure.
that has been pointed out, lordship, in paragraph 3, paragraph 2. What is the discrepancy?
Of the interest.
Yes, lordship.
Under
Discrepancy is
section
only in
61.
respect of the,
No, that is their lordship. My submission, lordship, because after issuance of the notice, that notice contains all the discrepancies. They prayed for, without filing any reply, they took adjournment on 5 August. Lord.
after 70,
Yes, Lord. In paragraph paragraph 3 of my affidavit, we have stated, Lord.
they were busy preparing the
That may be, but Lord, see, they could have filed their reply, but they have had before this honorable court, before the authority. It is not that,
but they did not.
no, yes, they did not, but now I am submitting, because Lordship, this is simply a notice, Lord. They could have availed this opportunity, whatever they stated before this honorable court, they could have had before the authority, Lordship. And it is not a case that the officer who has issued,
But then you have to ask the question that the school is gap. That jurisdiction,
no, Lordship, jurisdiction is there with the authority, Lordship, to issue notice under 673.
My lord,
but it's a very short, it's
I will.
an act.
We'll do a short written submission, my lord, with all the relevant page numbers of compilation.
We have you compare this one. The dates which are relevant and things are clarity.
We'll certainly do that. And my lord, just as a general comment, my lord, what needs to be deprecated? If the statute lays down a procedure, it is not for an officer or for somebody pleading on behalf of the officer to say at my discretion, I can write out certain rules and I can form my own rules.
We'll restrict it to that officer, not to somebody pleading on behalf of that officer.
We will, man. But that is certainly not acceptable because if according to them, they have 43,000 assessing officers, I'll have 43,000 different procedures to teach. That certainly militates against the predictability and consistency of it.
When are you likely to submit?
My lords will tell us, should we take 3 days?
Yeah, 3, 4.
So I'll also submit my written.
We are grateful. And I'm grateful to my lord.
After that. Yes,
At
are you
two
available at 2 p.m.?
At 2 lordship, I have another fixed matter lot.
Not
In the
available.
lease, dear lord.
Huh?
In the fixed, in the lease itself, lordship, it has.
No,
been-
this is more than fixed. This is part.
Yes, lord. Lordship, may start.
He can reply. You ask one of your colleagues to be there. That's all.
Lord,
He's
one
only
small
giving a
reply, I would
reminder.
like to, one small reply, lord, I would like.
Reply to a reply.
Lordship, 2, 3 judgment, only 2 judgments.
No, but you have to permit them to.
Yes, lord.
Reply.
Lord, let my senior colleague
Yes,
complete, lord,
let him
thereafter, lord.
All right.
Oblige. Lord, may the matter be passed for a time being. Learned Counsel G. Bodolo is a take. Matter may be taken after 2, lord.
All right. You are for the other matters.
For item number 13, that is also part
13 and
So, Lordship, I have some difficulty in the second half today. Can it be taken up on Tuesday next?
ask your only. I don't know.
Lordship. Any other hearing day next week? either Tuesday, Thursday, whatever is convenient to the Honorable Court.
Yes,
Okay.
you'll,
If you want to add something, I said you better do, therefore I can cover
I
the.
believe Lordship, my senior colleague has already completed that.
no, no, it's
Want to. That's not yet started.
I will end the matter, Lordship, then. At
No,
the
no,
end,
no.
Lordship, let my senior colleague complete.
let it-
Good, Doctor. নহলে আকৌ আপুনি আকৌ এটা আৰম্ভ কৰিব।
No, I told you already. Please follow.
no, you're arguing the matter, so you can continue.
No, if he wants to say something, my lord, he should finish it right away so that I can meet whatever again. Otherwise, I'll have to reply.
No, Lordship, my submissions will be only in response to whatever has been submitted on behalf of the petitioner. That is why I'm saying that. No, I have no issue, Lordship. I can complete, Lordship. But in that situation, Lordship, he will say something new, Lordship. I will again have
No,
to reply.
no, I have already made my submission. You have replied. Now, if you have to add anything, please add now because I'll reply comprehensively. Otherwise, till I reply, you again say something. I'll reply again. It is duplicate. So if you have something to say further, you better say it now.
Lordship, one specific paragraph, a prayer is there for regularization of service of the petitioner. Now the submission has been developed that even without regularization of service, he is entitled to pension. So to that point, Lordship, I have only one paragraph to read in the Upenda's judgment, Lordship. That is paragraph 22. Paragraph 23. For this reason, we are of the view
Yeah.
23.
Yeah.
For these reasons, we are of the view that in the fact situation of the case, masteral workers, workshop workers, and casual workers are not entitled for regularization of their services with consequential benefits such as pension, etc. So that is my submission, Lordship. So pension is a consequence of regularization. And one cannot claim pension without his service being regularized. That is my first point, Lordship. Even in the Prem Singh judgment, Lordship, in paragraph 36, before making them entitled to pension, a specific direction was issued that their services shall be treated to be regularized. So in that case also, Lordship, a specific direction was there. Their services shall be treated to be regularized only after they have been whole to be entitled for pension. So there also pension is a consequence of regularization, Lordship. Lordship, when I read Umar Prem Singh's judgment, Lordship, it reminds me of another judgment, Lordship, that is Puran Singh, Lordship. Puran Singh. Lordship, just like in this case, Lordship, deemed to be regularized or treated to, shall be treated to have been regularized. Indeed, in this case also, Lordship, Honorable Supreme Court, in this case, this citation is 2007-11 SCC 92. Yes, 92. 2007-11 SCC 92.
What is the party name?
Party name, this is State of UP State Electricity Board. UP State Electricity Board versus Puran Chandra Pandey, another. মই উলিয়াই থৈছো এইটো দি দিলা নেকি এইটো টান মাৰা আছে মই উলিওৱা ৰাতিপুৱা যিটো টান মাৰিছিল
Here.
টান মাৰা আছে। Paragraph 3, Lordship. By means of the writ petition, 34 petitioners who are daily wage employees of the Cooperative Electric Supply Society had prayed for regularization of their services in the UP State Electricity Board, hereinafter referred to as the Electricity Board. It appears that the society had been taken over by the Electricity Board on 3/4/1997. A copy of the minutes of the so-and-so. I am coming to the last three line of that paragraph, Lordship. In the said proceeding, it was mentioned that the daily wage employees of the society who are being taken over by the board will start working in the Electricity Board in the same manner and position. Pursuant to the said proceeding, the respondents herein were absorbed in the service of the Electricity Board. 5. Earlier, the Electricity Board had taken a decision on 28/11/1996 to regularize the services of its employees working on daily wage basis from before 4/5/1990 on the existing vacant post, and that an examination for selection would be held for that purpose. 6. The contention of the writ petitioner, the respondents herein, was that since the society has been taken over by the Electricity Board, the decision dated 28/11/1996 taken by the Electricity Board with regard to its daily wage employees will also be applicable to the employees of society who were working from before 4/5/1990 and whose services stood transferred to the Electricity Board and who were working with the Electricity Board on daily wage basis. I'm skipping this portion, Lordship. Paragraph 10. Paragraph 10, Lordship. In our opinion, the proceeding dated 3/4/1997 makes it clear that the employees of the society should be deemed to be employees of the Electricity Board with continuity of their service in the society, and it is not that would be treated as press appointment. And on this basis, Lordship, ultimately a direction was issued for regularization of their service under the Electricity Board, Lordship. Now, Lordship, this judgment came under consideration in the official liquidator case, Lordship. Here, Umadevi was also considered, Lordship. Official liquidator, that is 2008 10 SCC, Lordship. Paragraph 70, Lordship. Paragraph 70. The shift in the court's approach became more prominent in a Umadevi versus A. Umarani versus Cooperative Societies decided in a 3-judge bench, wherein it was held that state cannot invoke Article 162 of the Constitution for regularization of the appointment made in violation of mandatory statutory provision. 71. In state of Karnataka versus Umadevi, Lordship, I am skipping this portion. '75. By virtue of Article 141 of the Constitution, the judgment of the Constitution bench in state of Karnataka versus Umadevi is binding on all the courts, including this court, till the same is overruled by a larger bench. the ratio of the Constitution Bench judgment has been followed by different two judge benches for declining to entertain the claim for regularization of service made by ad hoc temporary daily wage casual employees or for reversing the orders of the High Court granted relief to such employees. However, in UP SCB versus Puran Chandra Pandey, on which reliance has been placed by Sri Gupta, a two-judge bench has attempted to dilute the Constitution Bench judgment by suggesting that the said decision cannot be applied to a case where regularization has been sought for in pursuant to Article 14 of the Constitution, and that the same is in conflict with the judgment of the seven-judge bench in Maneka Gandhi versus Union of India. But I am coming to paragraph 92. A detailed discussion has been made, Lordship, and on the basis of that discussion, the ultimate finding is at 92.
Yes.
In the light of what has been stated above, we deem it proper to clarify that the comments and observations made by the two-judge bench in UP State Electricity Board versus Puran Chandra Pandey should be read as arbiter, and the same should neither be treated as binding by this High Court, tribunal, and other judicial forums, nor they should be relied upon or made basis for bypassing the principles laid down by the Constitution Bench, that is in Umadevi judgment, Lordship. Now, if Lordship in this same state, Lordship comes to the Prem Singh judgment, Lordship.
Yes.
Paragraph 36, Lordship. Lordship, it has been clearly mentioned as Umadevi, Lordship. Lordship, it comes to paragraph 36, Lordship. Last line, Lordship. This court.
Paragraph
36, Lordship. Last line, Lordship. The court is. This court is. This court in the said decision, referring to Umadevi, Lordship, laid down that in case services have been rendered for more than 10 years without the cover of the court's order, as one-time measure, the services be regularized of such employee. Lordship, in my humble understanding, this is clear dilution of the Umadevi judgment, because paragraph 53 talks about 3 conditions, but here only 2 conditions were referred and made basis for declaring their services to be treated as regularization. One more point, Lordship, I would like to make, that is from the writ petition itself, Lordship. Page 35, Lordship. Lordship, this is the notification, Lordship.
page number.
Page number 55, Lordship. Lordship, this is the office memorandum, Lordship, by referring to which my learned senior colleague is emphasizing that this notification applies to those employees also whose services has not been regularized, but who has completed 20 years of service. Lordship, may kindly read this OM, Lordship. In the government,
You
government,
submitted only.
Lordship,
You already submitted.
just one word, Lord.
Ah.
Just one word. I am referring to just one word. In the Government of Assam circular issued under the office memorandum number so and so, dated 10/8/63 of Finance APF Department, a temporary government employee who retired after rendering temporary service of not less than 20 years under the government without being confirmed in any post. Lordship, kindly, Lordship, my petitioners, let them show, Lordship, which post they are holding. Where is the post? That much only. History part.
My please.
Just one.
Milord, have pretty with my submission and also cited the judgments in support. I'll very briefly indicate what is the reply, and I would like to indicate a few other things which emerges out of that. But this case is in a very short term. It's not a case of regularity. These gentlemen who are here, they have already served out their period of service because they have been superannuated after reaching the age of super. So, regularization involves a case where all these cases where people are still working for some 10 years, might be said, if you have worked for 10 years, you have a scheme of regulation and all that. I am not on that. The short question is, if a man like the petitioner, who is given an appointment by an appointment letter, who is given a scale, who is given increment and all other allowances, and he is officially retired on receiving the attaining the age of superannuation, would he or would he not be entitled to pay? That's the short question. I am not therefore troubling your lordship with the regularization. We are relying on two notifications of this government.
Can you come back to the question again? What is the question that you're trying to
Milord, what I am trying to submit is that if a person is appointed in government service and he is given a scale, his increments are regularly given, and he is superannuated from his service by a notice. Is he or is he not entitled to pension? That's the short issue. In the context of these two notifications issued by the government itself, namely at page 55 and 58, 57, which are really mirrored under Rule 31. of the Pension Rule 16. In terms of this is a question which did not arise in Umadevi or in any of these regularization cases cited before. Therefore, my lord, the cases cited, starting with Umadevi, has no relevance so far as this issue is concerned. This issue, for the first time, arose in Prem Singh. Here, your lordship has two categories of employees, work child. One whose services were regularized, and the other group whose services were not regular. The court didn't make a distinction. Court said these are the monthly payment, increment, and all these features which are consistent with a regular employee, they also have. Therefore, they are deemed to be regular. Regular, not regularized. They are deemed to be regular. And you cannot deprive pension when they reach the age of super. In my humble submission, my lord, subject to what my friend may say, the two notifications at page 55 and 57, which are in terms of Rule 31 of the pension rule, the lordship have seen them. Rule 31 below. All right.
Very bad. Yes.
Your lordship want
Yes.
Rule 31 below. The service of an officer does not qualify for pension unless it conforms to the following three conditions. I'm sorry.
Yes.
First, the service must be under the government. There is no dispute on it. Secondly, the employment must be substantive and permanent. We'll examine this because that can only have some relevance. Thirdly, the service must be paid by the government. So this also is satisfied. So for second condition is employment must be substantive and permanent. Now kindly see the proviso. Provided that the service provided that the governor may, even though either or both of the conditions 1 and 2 above are not fulfilled. One, in our case, there is no dispute. So far as the second condition is concerned, which is, my lord, that it must be substantive and permanent. So this proviso carves out a power for the government to waive that condition. It says, provided that the governor may, even though either or both of the conditions 1 and 2 above are not fulfilled, declare that any specified kind of service rendered in a non-gazetted capacity shall qualify for pension, and in individual cases and subject to such conditions as he may think fit to impose in each case, allow service rendered by an officer to count for pension. So these are the powers conferred on the government as a proviso to the main part. Now, pursuant to this, now kindly have a look at page 55. And 57.
55.
55 of the
Notification.
petition.
Yeah.
Annex 30.
Yeah.
This is below 96 September 12, September 96. In the Government of Assam circular issued under Office Memorandum dated 10/8/63, Finance Department, a temporary government employee who retires after rendering temporary service of not less than 20 years under the government without being confirmed any post is to be allowed the pensionary benefit as available to a retiring confirmed government employee either on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by the appropriate medical authority. The state MO came into force with effect from 1/9/82. The governor of the Assam is now pleased to clarify that all temporary government employees who have retired from the service under the governor of Assam, fulfilling the criteria of not less than 20 years of continuous service, will be eligible for pension from 1st September 1982 onward. This is, however, subject to the condition that they satisfy all conditions other than the conditions of permanency against permanent post under Government of Assam for usual pensioner benefit under the Assam Services Rule 69. This benefit not be admissible to any retirees who retire from the service with retirement benefits under CPF. CPF we don't have. That is mentioned in our page 30. Therefore, this is supplemented below. This is of 96. Now, at page 57, we go to 2003, 6 September 2000. In continuation of this OM dated 12/9/96 at page 55, it is reiterated that the said OM clearly lays down that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits. The servant, the focus is on 20 years of continuous service after rendering 20 years of service, if the government servant is superannuated or incapacitated or dead, is not the root point. Any confusion in this regard is against the spirit of the OM referred to above. It is therefore clarified that pensionary benefit as contemplated in the OM shall be admissible to a government servant who died after rendering 20 years of continuous service. Other terms and conditions of eligibility of pension shall remain same as usual. Nothing can be more clearer.
The government,
Who is appointed as a government servant?
are you appointed?
Yes, that my appointment letter is there.
What are the parameters? That the government-
And the pension letter, the superannuation letter,
No, that,
it,
how do you, how do
it,
you,
it just says that, Willard.
how do you project yourself to be a government officer? What are the requirements under the law to claim a status of a government servant?
Willard, an appointment paid by the government. Service record maintained by the government. Increments annual. That's a government servant, that's a regular servant. And therefore, Prem Singh says, if this is all that is given, then he is a regular, he is like a regular employee.
No. The question the court is putting to you is in view of the mention in the OMs which you are relying on.
Yes.
There is a term used that government employee, government servant.
Correct, Miller. Kindly see my appointment. What else it is? I am paid from government checker. My service book I have placed before your lordship.
Is it sufficient to make you a government servant?
Of course. Who else will be a government servant? In the at page 24, the appointment. In the interest of public services, Pramod Kakoti, so is hereby appointed as work charge section assistant in the scale of pay of so much, plus other allowances as admissible under rule in Boko Road subdivision. The appointment is purely temporary and may be terminated any time without notice. We have really turn to page 48. Pulin Bihari Oja, Boxer Section Assistant of PWD Guwahati East Road Subdivision under this division is hereby released from the government services with effect from 31/3/29 on attaining the age of superannuation.
Yes.
This Miller, the appointment and the termination, they themselves indicate that it is under government, and the condition that he must get the service must be under the government. It is the first condition.
Yes.
And the appointment and the employment must be substantive and permanent, and the service must be paid by government. Government is paid. And the proviso.
The query put to you is only in the context of the notification.
Yes, notification is at page 55. Temporary government employee. Temporary and regular permanent, it
okay.
is a question of tenure.
All right.
They are defined in fundamental rules. And it says, my lord, that about temporary government servants. In the government circular, issued so and so number, a temporary government employee. Temporary government employee means duration is the yardstick, to find out whether it is temporary or regular. Hmm? It is this notification is for a temporary government employee. Temporary government employee who retires.
55 says temporary government employee, 57 says government servant.
Same thing, employee, servant, there is no difference. Interchangeable word. And it says temporary government employee who retires after rendering temporary service of not less than 20 years under the government without being confirmed in any post is to be allowed pensionary benefits as available to a retiring confirmed government employee either on attaining the age of superannuation or under those three conditions, death or medical wrong. So there is no dispute that he is not a government. He has drawn money from the government. He is appointed by government. His entire service is with the government in the predominantly. And the other condition of permanent and substantive, that the proviso deals with it and enables the government to either say that these conditions can be modified or dispensed with, or and even in individual cases, second Roman 2 of the proviso, even in individual cases, they can take note of individual difficulties and grant pension. Ultimately, what is pension? The Lordship have explained that the purpose and object of that pension. It is not a bounty. It is property. Right from 71 onwards, that Constitution mentions subsequently Nakara and all that. So it is, you take the service and he retires, you recognize his service by way of a pension. So that in his evening years, he has some comfort for rendering the service to the government. That's the whole object. And therefore, although the Rule 31 literally 1, 2, 3 conditions, the proviso is giving an exception so that government can, whenever it thinks it is necessary, issue, waive and modify the earlier code. That is why these two notifications. So these two notifications have not been examined by any court in any of these decisions. That is the whole problem.
That's the category typing by a division bench. The
Correct.
master roles are not cited.
Correct. That I'll deal with it. Your Lordship, he cited that last case, division bench. And I'll show, my Lord, these two notifications were never placed.
Very good. That needs to be reconsidered. Because that finding of the division bench,
Correct. But,
finding,
but that division bench judgment should have had the benefit of the Prem Singh judgment.
that was prior to Prem,
No,
after.
Yeah.
Not prior. Right?
no, no.
Now the
23, that is 2019.
what if you can the
Prem Singh is 19. Human? That too.
division bench judgment is 14. I think. Is it 14?
Upendas is 17.
17.
19.
This Prem Singh comes three judge bench, my lord. That is on 2nd September 2019. And this single bench, this division bench here, this is 13/3/23. After Prem Singh.
It is decided on 2017. Upendas.
Wellness 17, I am talking about the last judgment 23, my lord.
13 point.
Ujala Narjari. That is 13/3.
No, we are not on Ujjwala Nazar. We are
Yeah.
on Upendas.
Upendas is much earlier.
Ah.
17.
Right.
So that question was not therefore dealt with because Prem Singh comes in 2019. That's why, my lord, my humble submission before your lordship is that Prem Singh is of the first time dealing with workers employees. And with the question whether pension is payable to them or not. One,
No, then what do you say about the subsequent division bench judgment?
subsequent division bench judgment, my lord, with great respect, my lord. This Ujala Narjari case. The lordship is referring to that.
Yes.
That, my lord, this is a 23 judgment. There are two things missing in this. One is Prem Singh, because that really dealt with this issue. What is this Ujala Narjari case, my lord? Two widows are before the court. Their husbands have worked for 20 years. They said, give us some pension.
The proper thing to refer that, but we consider.
You know, if your lordship had disagreed or had a different or a doubt,
No.
What I am saying,
if
if
Prem Singh rules has clinched the issue,
yes,
so far as the petitioner you are concerned,
Yes.
then the Ujjwala Narjari also
yes,
returns a finding that they are not entitled to pension, etc., in
Correct.
spite of all this. But that was done pursuant to Prem Singh.
no, subsequent to
Subsequent.
something without referring to
That's
pension.
right.
Therefore,
So therefore, Prem Singh ought to have been considered.
should have, with respect. But what is the position so far your lordship is concerned? Your lordship
We are
your
amongst
lordship
other
is
things.
having Prem Singh.
we are amongst other things. we are also concerned with the fact that there are two division bench judgments against you to the effect that master rolls will have no claim to
With great respect,
regularization, pension, etc.
with great respect, Miller. Law is a evolutionary process, as your lordship said. Prem Singh has reached a stage beyond Umari and
No, no.
deal with
We
a case.
see the issue. There are some, you know, there are some technical issues to be
Correct.
considered.
Yes,
Now, in the face of a division bench judgment,
yeah,
as opposed to, or in the face of a Supreme Court judgment, which has not been referred to in a division bench judgment. Division bench judgment otherwise is binding.
correct.
Now the question is whether this court can proceed to decide this issue by merely referring to the Supreme Court judgment to say that this judgment not having been considered, perhaps the division bench judgment is not binding. Whether it would be correct,
Yes.
or better to refer it to the larger bench to reconsider this issue since Prem Singh was left out, not considered.
With respect, if your lordship is now faced with this question, yet it is a matter covered by Prem Singh. Here is a division bench.
No, we are not on that. We are on that Prem Singh does deal with this issue.
Yeah.
Whether Prem Singh is applicable to the fact of this case or not,
This
is
is
different
a
issue.
second.
But it does deal with this issue.
Yes,
This judgment was not referred in the division bench,
correct.
not discussed.
Therefore,
Implications of whether it would be applicable or not was not even got in.
correct.
Now
Because it was not cited.
it was not cited
Yes,
or it
that's
was not
right.
discussed.
Now, what will be the position for future judges when they come across with the same point? Like your lordship is having this problem.
So therefore,
Then, my lord, it is not the division bench which your lordship will be guided. Right? Your lordship will be guided by the Supreme Court judgment. That's the law. Anything
it requires some authority on
that will be available. My lord. If your lordship want, I will give your lordship that authority.
But-
Because suppose it happens, my lord. It's not the first time that it is happening. It has happened in other cases also, and where the court said that if the
So there are other judgments which say
that is all right, so far as suppose there is no Supreme Court judge. Your lordship is not happy with a single bench. What will your lordship do? Your lordship normally say that it may be referred to a division. Or a division bench, if he is confronted with that, it will say larger. But if there is a Supreme Court judgment, which is on the point, then that option is not there. Your lordship is bound under 141 by the judge. And your lordship will not be bound by the single judge or the division. That's the law. That's the legal position.
all right. So that's it, I think.
I'm almost closing. Here also the same thing, Ujala and I. They are master role workers, not workers, but substantially same sort of temporary employment. And the widows were before the court. And pension was the only issue. It says that it is not eligible, and they are relying basically with Uma Devi. The trouble is,
Just,
we have,
just
I'm sorry. So in this case, my lord, these two notifications are also not mentioned, although in one, the first notification is date is same, but the contents which have been spelled out is somewhat different. That's why I am thinking that there can be other notifications also. Because this is a case relating to master road, therefore I don't know what that notification is, but from what I find, it is
So, but what your case is on prem-
my basic case is under fencing because that in my
Therefore-
humble submission, that is the first case.
having worked that period with all the traffic of a regular government employee.
Not
there's
traffic.
no-
I am a government employee.
for the parameters, but
Yeah. Yeah.
for a government employee.
Yes. Yes.
Therefore, there's a question of regularization. Big question there.
No, Miller, there could be a case of regularization, but if after retirement happens, regularization as a precondition for pension, my respectful submission is not needed. Considering the nature of the right involved in the concept of pension.
Rating judgment has regularized with a deeming.
It directed. Your Lordship kindly see that paragraph.
There are
True book,
one regularized but not having
not
the
regularized.
required
Therefore, it says that
deemed to be
it seemed to be. That is my prayer. Because while we
Therefore, you can't say that you're not actually the question of regularization is not applicable. According to you, question of regularization has to be accepted in the line of praising the society
absolutely, Miller,
that it is deemed regularized.
absolutely,
And you have put in that survey.
Yes.
Put you satisfied to 31. Therefore,
Yes.
when-
Yes.
And,
and I am covered by the two notifications.
no, even otherwise,
Even
even if these two notifications are not applicable,
yes, fencing is
everything is there, you satisfy the requirements under 31. Therefore, when-
that is my humble submission. And therefore, Miller, if I'm not being very technical, but my learned friend was mentioning about our prayer. If your Lordship sees, the first prayer is, Miller, at page 20 of the deed. Roman 1.
Yes.
Issue a rule calling upon the respondents to show cause as to why a writ, order, or direction in the nature of a declaration that the petitioners have been deemed to be regular employees in the facts of the case by the respondents and are entitled to pay. This is really in terms of preempting, because if your Lordship sees, my learned friend had just said, yes, very good.
Now, if this is allowed, then the consequential prayer has to be allowed.
Yes.
For pension.
This is my substantive prayer. If your Lordship sees preempting 36,
Yeah.
para 36,
We have seen it.
yes, your Lordship has seen it.
You want us to see again?
No, I'll just, one line I will read out so that.
Yes.
33 also talks about that it will be one class, and there should be no discrimination among the workshop employees. And then 36 comes, Milord. At page 33, 541.
Yes.
As they have worked in the workshops establishment, not against any particular project, their services ought to have been regularized under the government instructions, and even as per the decision of the Uma Devi, this court in the said decision has laid down that in case of services have been rendered for more than 10 years without the cover of the court order, as one-time measure, the services be regularized of such employees. In the facts of the case, those employees who have worked for 10 years or more should have been regularized, should have been. In our case also, if you had the Uma Devi, we have crossed 10 years, you should have done it. Your default should not enable you to tell us that you don't get pension. It would not be proper to regulate them for consideration of regularization as others have been regularized. We direct that their services be treated as a regular. That's the first prayer. Give a declaration that they were regular candidates, employees. Because ultimately, my lord, (226) is an instrument in the hands of your lordship in the High Court for a purpose, in my humble submission, which can have very many manifestations in order to give relief not only to individuals but to the society or the state as a whole. Why am I saying that? Just see the nature of the evolution of that right. When we joined, if I may just say in 67, the controversy which was most prevalent in dealing with a writ was what is your legal right? Invariably, the arguments will be on that issue first. Now see the position today. What a journey 226 had at the hands of judges as an instrument of social justice, if I may say. Think of the bonded labor. Think of all others which are covered by these new developments. And we not just see what is a right that has also expanded itself. Civil consequences. Binapani first said in 67. It has civil consequences, your pay for your service. Therefore, natural justice applies. Then, Milord, your Lordship has 68 Anglo-Afghan promissory estoppel. Could you have imagined, Milord, that on a promise you are going to issue a writ?
Oh, now
It has gone further.
in promissory estoppel.
Promissory estoppel has gone further.
But there are twists and turns.
Twisted turns, even among themselves, there were those two judgments. Godfrey Phillips will not resolved it. The Lordship remember that first judgment of two judges was not agreed to by the second judge, two judges. Therefore, Godfrey Phillips came in 78, I think, where it was said, and Justice Bhagavati was in the earlier case and also in the Godfrey Phillips. So he took trouble to expand and explain that when this kind of thing happens, another division bench cannot overrule the other division. You must refer to a larger. That's the practice. And then Godfrey Phillips came. And kindly see, when Mahendra Singh Gill was decided, what was the right? It is a community right which was upheld. Can you countermand the election? Because people or voters or citizens have a right to see, what is their right? Right to see that election is conducted in accordance with law. That's the right. And Mahendra Singh Gill, para 66 says civil consequence. That includes even interest, forget right. Interest of the people. Therefore, it's a very beautifully
So also fine good point.
but it's a big difference,
Yes, yes.
to everyone.
It's
So-
still a very good talk.
So this, the question of a pension for a government servant is a very crucial thing because he gives his best, as they say in one of the judgments, and then, the government takes care to some extent their post-retirement difficult. Otherwise, these two notifications reveal that anxiety of the government. It says that a person who is not confirmed, he is going to get it. And what is permanent and that's why I was citing, that case. That Dwarka Das case, Dwarka Nath. I'm quoted subsequently in some judges, not quoted also, and without acknowledging this line is there. That's para 4, after quoting Article 226. This article, my lord has got it.
Yes.
This article is couched in comprehensive phraseology, and it expressly confers a wide power on the High Court to reach injustice whenever it is found. That's the extent of your lordship's power. This is very simply put, but of great import. And what else is the division bench case, Two widows are before the court. Their husbands have gone. Whether they get the pension or not, that's the question. And these two notifications clearly cover. And what we are now doing, the same thing, They have worked all their life without blemish. They got all and treated as a regular employee. Only at the fag end, after retiring us, they said that except pension, you will get everything. why should that pension not be given? There has to be a reasonable basis for it. Their own notifications will not empower us.
Lordship, I think
Yeah.
if I do not cite this one rule, Lordship, it will remain inconclusive, Lordship. Rule 152 now,
Okay.
pension, just one rule law.
Okay, you do it, but let me complete. No?
Sir.
Now, what is substantive? There is a judgment, that's why I wanted to make Krishna. There is one judgment of Justice Salemeshwar Milot, your Lordship, Rohit Nihal Singh case, 2013,
Punjab.
14 SCC, page 65, where in one where he put it very bluntly. Para 20 at page 74. For instance, Milot 2013, volume 14, SCC, page 65. Para 20. About sanction postponement. This is last sentence of that paragraph. Sanction posts do not fall from heaven. The state has to create them by a conscious choice on the basis of some rational assessment of the need. So much is about Ruma Devi. Even going by the principles laid down in Uma Devi, we are of the opinion that the state of Punjab cannot be hard to say that the appellants are not entitled to be absorbed into the service of the state on permanent basis, as their appointments were purely temporary and not against sanction posts created by the state. So that was there even earlier. My learned friends have given me a judgment below 1991, 4 SCC 139. Paragraph 41.
The name of the party.
State of UP and another versus synthetic and chemicals limited.
Can you repeat?
State of UP and another versus synthetics and chemicals limited and another. Atheni.
This is for what proposition?
Subsilent show, they say. If you lost it, Para 41. Because it's not a complete judgment, they have just got it, and the relevant paragraph is paragraph 41 that is given.
This is about precedent.
Precedence, because Ujala has not considered the two notifications or the earlier case. Therefore, it will not be
Therefore, what is not considered cannot be treated to be a precedent for that purpose.
Absolutely. Now that substantive also I want to read out a paragraph. Quotation. It will be- the substantive paragraph. This is Milord 1980. 1980, volume 4, SCC 226. I will read Milord paragraph 31 at page 243. Para 30, Milord refers to that
Confirmation.
just Patavardhan case, where Milord it refers to a case of a High Court judge being confirmed, and thereafter he is getting a confirmation as district judge later. So that is that can happen also. Where it was said that confirmation is one of the inglorious uncertainties of government service. Now I am reading out, Milord, only one paragraph, paragraph 31, at the bottom of page 242. What in the context is a substantive capacity vis-a-vis an appointment to a post? In our view, the emphasis imparted by the adjective substantive is that a thing is substantive if it is an essential part, constituent, or relating to what is essential. We may describe a capacity as substantive if it has independent existence or is of considerable amount or quantity. What is independent in a substantial measure may reasonably be described as substantive. Therefore, when a post is vacant, however designated in official, the capacity in which the person holds the post has to be ascertained by the state. Substantive capacity refers to the capacity in which a person holds the post and not necessarily to the nature of the character of the post. To approximate to the official diction used in this connection, we may well say that a person is said to hold a post in substantive capacity when he holds it for an indefinite period, especially of long duration, in contradiction to a person who holds it for a definite or temporary period or holds it on probation subject to confirmation. That is how substantive meaning has come, because let's say Okay. In fact, my lord referred in one of the earlier days, Kubiram Rajvanshi.
we have-
Reread, I have reread. That was decided in 97. Credit must be given to our High Court,
Yes.
my lord. He
far
said,
advanced.
pension is not a bounty you must give, and that was allowed.
And subject to correction, perhaps no appeal was filed.
I have seen right there. So this point, my lord, with respect, my lord, and Uma Devi, really speaking, my lord, has no relevance for our purpose here. And Uma Devi has been explained. I have already cited the judgment of several judgments, where, my lord, it was said that there are 2 points which have been decided there. One, that problem, if your lordship recall those days, where there was a lot of illegal appointments to the backlog. So that was one which was thought to be done away with. And the second thing was, they did not throw out all the people who have come into the service through that process, because they said that if you have worked for 10 years, have a scheme for regularity. That subsequently, I cited that also, Chandrasud and Justice Lokur also. Both have explained what is one-time exercise. They said that all the people must be considered. It's not just that one lot you have considered and over. So we are not concerned with those. Therefore, basically, Uma Devi was on that issue. And therefore, we are really not on Uma Devi. We are basically this point which we are raising and which is covered by their own notifications at page 55 and 57 is governed by Prince. And these two notifications, I don't see anywhere except in one of the judgments. Date is same, but the contents do not match, because they said that for pension you have to reduce some years or something, which is not there in this notification. In one of the notifications, 2003 notification, there is a reference in Ujjwala Nazari, but that also says the contents and says that it excludes 5 years for something or the other, which is different, therefore, than what your lordship finds at page 57. So, in my humble and respectful submission, in view of their own notification, these people are entitled to pension. They are having served them well for all these. And you can now,
So that's one rule, my lord. 152. Lordship, may kindly see the chapter 9, and the headline is Temporary Government Servants. 52.1. A temporary employee who retired on superannuation or is discharged on account of retirement or is declared invalid for further service will be eligible for a gratuity at the rate of half a month pay for each completed year of service provided that he had completed not less than 5 years of continuous service at the time of retirement, discharge, invalidation. So this is the provision, Lordship, which gives the entitlement to a temporary employee to provident to gratuity, Lordship. Now, if Lordship comes to Roman 3 down, no gratuity will be admissible. Now, Lordship may kindly see D. To one paid from contingency or one belonging to a work search establishment. So a person who is in work search establishment is not entitled to gratuity. Now, Lordship would definitely like to see the definition of pension, that is Rule 9.
Yes.
Rule 9, that is pension.
Rule 9.
Yes, Lord. Now, Lordship may kindly see the definition of pension, except when the term pension is used in contradistinction to gratuity. Pension includes gratuity and death cum retirement gratuity. So a person who is not entitled to gratuity, he will be entitled to pension. This sounds something absurd, Lordship. And if again Lordship come back to that chapter, Lordship 152, if Lordship comes to the next page, Lordship, that 2003 OM is there, Lordship. Lordship, this OM contains in the chapter of temporary government servants, and this notification applies only to the temporary employees discussed in this chapter, in the context discussed in this chapter, Lordship. That is one, Lordship. Lordship, that judgment of Prem Singh was, in that judgment, Lordship, I was also there present, Lordship. I was also appearing on behalf of the department, Lordship. Prem Singh was placed before the court. But that Ujala Nursery. But for some reason, Prem Singh was not referred to. That is one. But in the judgment placed by me, Lordship, in the WPC number 1177, already there, Lordship, Prem Singh was placed and discussed. One. Secondly, Lordship, this issue of opening of service book was also discussed in this judgment. Thirdly,
Which judgment? Single bench.
yes, 1177, 2017. And the issue of getting scale pay was also discussed there. So all these issues, Lordship, scale pay, opening of service book, plus Prem Singh were issues in that judgment, and the learned single judge decide that issue, Lord.
Yeah.
1177, 2017. Obliged, Lord.
That's it.
Rule has nothing to do with us, so that is with regard to gratuity.
Heard. Counsel for the
Our notification says if you are having CPF, this is law. We don't have
Obliged.
CPF.
Yes.
Please, Your Lord. My Lord, by this writ petition, I am challenging the selection and appointment of respondent number 4, basically, my Lord. The respondent number 3, my Lord, District Deputy Registrar issued an advertisement for appointment of process server peon and peon. The petitioner being qualified, he applied for the post of peon, man. Then, my Lord,
This we had heard it before.
yes. It is part
There
of,
were some
yes.
results were declared and
Yes.
general became
General,
PT,
yes.
and then it was rectified.
Huh?
That
That has been rectified, yes.
Normally, they said they have been corrigendum was issued. Then on last occasion, Lordship directed file an affidavit to bring on record some of the to bring on record some documents, my Lord.
That we have filed, Your Lordship, by way of an additional affidavit.
you filed it.
Yes, Your Lordship.
On 30th of April, May.
What are these documents?
Lordship, page number 92, that is the minutes of the meeting whereby the decision has been taken and the corrigendum was issued on the very next day, that there were some clerical mistakes, Your Lordship. Page 92, Your Lordship. Page 93 is the relevant portion, resolution number 2, Your Lordship. The chairperson apprised the board that due to unintentional clerical mistakes, few errors have been detected. In case of the peon post, the roll number 21, which was shown in OBC, would be transposed to general unreserved category, and the candidates bearing the roll number 38 shown in the general category would be transposed to OBC category. Further, the roll numbers of the two successful candidates in the PSP post vis-a-vis 149 and 855 did not feature in the notification. The board unanimously released to notify the same in the corrigendum notice at the earliest on the notice board of the office, Your Lordship. That corrigendum, Your Lordship, is I have already annexed in my affidavit in opposition, page number 76, Your Lordship. Apart from that, Your Lordship, the other documents which I have annexed in the additional affidavit is in respect of the roll number 38 candidate. He belongs to the OBC category. His OBC certificate and the other documents I have annexed, Your Lordship. Those are part of the original record.
Petitioner claims to be
OBC.
OBC. What is your name?
Sumit Palman, roll number 60.
What about his papers? His papers are in order.
This aspect, most probably not.
These papers, Lordship, applications, Lordship, I have not received. What I have received is in respect of the roll number 38 and the minutes of the board meetings, Your Lordship.
They have not raised any question with regard to my OBC status, my Lord. They have filed affidavit. First of all, my Lord, the first affidavit was filed in 2023 by one Lipika Sarkar, respondent number 3. They have not dealt with the paragraphs of my writ petition. Simply say the process was fair and no illegality was committed. Nothing more than that.
How?
Yes, my Lord.
Error. They have rectified.
No, my Lord. May I submit? Earlier their stand was that there was some clerical error. Therefore, it was by issuing a corrigendum which was published and rectified. Actually, no corrigendum was published, my Lord.
With what they went to?
No, they have enclosed. It was not published. Now, after the affidavit that which has been filed on 30th of April, my Lord, by the same another D. Bora, who is also respondent number 3. They have changed their stand now. They say, no, it was not clerical mistake. It was roll number 21, which was shown wrongly to be as a OBC candidate. Now he would be transposed to general category candidate, and respondent number 4 would be transposed to OBC candidate. They have two different stand now.
How many PTR?
Two or three something. My lord. Two posts.
Anyone appears for 149 and 855 roll numbers?
My learned friend,
I would appear for 4, 5, and 6.
What was your roll number?
My roll number is 038 so far as he is concerned.
I'm reading from the prayers of the writ petition.
My lordship.
You look into para.
Prayer is general and specifically so far as his case is concerned. I've got to the page 10
Page
the writ
11.
petition. May I read that, my lord? In the premises aforesaid, it is therefore most humbly prayed that your lordship may be graciously pleased to admit this petition. Call for records, issue rule calling upon the respondents to show as to why the illegal appointments made by the respondents to the post of peon by appointing general category candidate against the reserve category post and the candidates in roll number 149 and 855 who were appointed illegally, though they have failed to qualify in written test, should not be quashed. That is the basic prayer.
Who is roll number 149 and 8?
I appear for 149, 855 and 38. My most respectful submission would be his case is confined to 38. He had vied and applied for the post of a peon, and therefore the entire hard punning or the grievance would be confined to the post of peon, which I would clarify. The rest, PSP, he had neither applied nor not, and they take a stand, which I also support, that there were some errors which had been rectified. Now, my lord, so far as the writ petitioner's case is concerned, he says that swapping or transposition was not done in all fairness. Now, this aspect of the matter was never brought to challenge, if at all could have been challenged. 2015, the incident occurred. 2014, the incident occurred. When 2025, we have been appointed and confirmed in services. And now, this technicality which comes in his way is that this is not under challenge. Firstly,
What is not under challenge?
the corrigendum is not under challenge. There could have been a compelling argument made
Yes.
that the corrigendum is an eyewash. Could have been made. Whether or not that holds ground, whether or not he sails through, the challenge is not forthcoming even as on date.
It's challenge
Correct.
the appointment.
Therefore, I address that issue. My lord, our stand,
Irrespective of whether he challenges
regardless, that's my first claim which I pointed out. Now, when the writ petition was filed,
you applied for which
peon, both peon.
and Mr. Modi's client is also
When the writ petition was filed, we take it as we proceed in the matter. When the writ petition was filed, we time travel to the point of advertisement, which 21st of January 2014 at page 15 of the writ petition. My lord.
Eight.
1-5 of the writ petition. This is the point of no grievance. From here, the grievance may come up. Applications are invited in standard form of application as published under so and so and so and so. From the eligible candidates for filling up the following grade 4 posts under the establishment of District Deputy Registrar of Cooperative Societies, Karimganj, as per eligibility criteria mentioned below, application must be addressed to the District Deputy Registrar of Cooperative Societies, Karimganj. So far as B is concerned, serial number peon, I skip A for a moment. B is peon. It says the total number of 9 posts. OBC, MOBC would be 2. Unreserved would be 7. My lord, may I rephrase my submission? It's given OBC / MOBC and unreserved. Not OBC and general. It's given OBC / MOBC and unreserved. That's 2 and 7. The next page 16, which is my colleague's document, it is the call letter. He claims, and we do not doubt his bona fides to say that he belongs to an OBC category, but the call letter does not indicate. So, therefore, on the same stand, the call letter issued to me, which I have so annexed in my affidavit, does not reflect the status of my reservation. So neither I nor he had any reason to doubt the bona fides or the correctness of the procedure so being followed by the authority. We come to at page 17, that's the notice, 19th of February 14. This although gives the numbers, but if I may just indicate one thing, we skip for the PSP for a moment, my lord. The peon part, lordship is there. Peon part has two bold categories. I'm not in the roll numbers, I'm in the categories. The first category is OBC and the second category is general. And it is not OBC / MOBC and unreserved as it ought to have been as per the advertisement. This is an error apparent on the face of the record, which should have been corrected. And so did they correct. This was not brought on record, which we had brought on record.
No, the roll number is 60.
His
60 mine.
60.
Petitioner.
60. I mean, this is one part of the correction.
And 38?
38 is mine.
38, respondent number
One part of the correction is OBC general.
4.
So, my lord, one part of the correction would be the OBC and the general, and the other part of the correction would be the numbers whether properly inserted.
Wrong here.
Correct. So far as OBC is concerned, they clarify, if lordship takes up the affidavit of respondent number 4 for a moment.
The affidavit, additional affidavit.
No, the affidavit filed by respondent number 4. Opposition.
Yeah.
Page 30. So as on 19/2/2014, when the notice was published, neither of us had any reason to believe something went wrong. But I could come to know that my name was put wrongly in the general. Before I could get things done, the next day they come up with a corrigendum. And what do they correct? They correct two things in two parts. The first part is OBC becomes OBC / MOBC, just like the advertisement. I'm on the peon part, my lord. And the second, the general becomes unreserved, as like the advertisement. This is the first correction. And the second correction under the category of peon is that the roll numbers 21 and 38 gets interchanged. So there was an error on the category so far as roll numbers 21 and 38 are concerned, and corrected the next day itself. Only 21 and 38 gets changed, nothing else gets changed. The name of the category and the roll numbers to the extent of A and 21 and 38 would get changed.
Who is 21?
21 is not arrayed as a party here in Miller.
Only by this affidavit, they have now said on 30th of April that it was by mistake roll number 21 was shown as OBC candidate. When malleability, the roll number 21 appears twice in the record.
In?
My lord, my affidavit, just a moment. My affidavit was filed on the 3rd of
No.
April 23.
102 does not contain the roll number of the petitioner.
My lordships.
What? This page number 30
Yes, my lord.
doesn't contain the roll number of the
It
petitioner.
does.
Where is
It does.
Where is it?
So far as OBC, may I read? Category OBC, MOBC,
Hmm.
instead of OBC, with roll numbers 038, 040, 060. Meaning thereby, in the viva voce, I perform better. His reservation status is intact. I performed better. That would be the simplest meaning which can be ascribed what the authorities have done.
Yet we don't know.
Of course, Milord, 038 comes in. I am an OBC, which is not disputed. Now, the call letter would not reflect my caste status, my reservation status, if I did not know. When 19 they erroneously did it, 28 they bring up the corrigendum, so I had no reason to be aggrieved.
No. That you perform better than him is not reflected from the.
I was selected, rather.
That is.
I was selected, rather. But I bring this fact on affidavit on the 3rd of April 23. Today we are exactly 2 years past. We've crossed 2 years, 25. And this is what I'm saying, that my lord, after this selection, I was appointed. That's at page 32, 28th February 2014, and confirmed 12th of May 22 at page 34. Essentially, my lord, when they realized that there was an error in naming the category and in insertion of the roll numbers, only 2 roll numbers got interchanged, 21 and 38. 21 is not aggrieved because he is a general category candidate. I am not aggrieved because I am an OBC candidate. Now, I perform better than him or I was selected is not the hard-burning issue. The point is how I could become an OBC. When then he has to go back to the Madhavi Patil's case, my entire caste status has to be seen. That is not under dispute, my lord. But they do, in all fairness, same things for all.
He wanted them to bring the documents on record. So, what was the caste reflected?
Correct, absolutely, they should. They certainly should.
They brought it.
They brought it now. But had they had a case that I am not an OBC, but I'm falsely projecting my case to be an OBC, I could understand. But that is not their case. And as on the call letter stage, I could not have known. He or he also could not have known. We're selling on the same parameters. That's all. Rest my case,
My lord, my another point of argument, my lord, Lordship has seen the corrigendum. I could not understand what they want to say by the project by this corrigendum. My lord will see roll number 21 appears thrice. In the page, just my learned present, page number 30 in his affidavit, or main affidavit in opposition, page number 76. Yes. Page 76, affidavit in opposition.
76.
Yes, ma'am.
Whose affidavit?
Respondent number 3, my lord.
That's not the, yeah. Page
76, my lord.
Yes.
Yes. Now we will come to down below peon, category of peon, left hand side. Then, my lord, the first, second line, my lord, instead of 21, their roll number 21 appears. Then again, below category unreserved, instead of so and so, 21 in the first line, my lord. Then again, in the third line, 21. APS price, what they want to project by this.
Whose roll number is 21?
Now they have brought on record, my lord, that earlier they said it was a clerical mistake. Now, by
whose roll number is 21?
I don't know. Now they say by this affidavit that roll number 20 was wrongly transposed to OBC category. Now it would now be transposed to general category. But here it appears thrice. They say by corrigendum they has corrected. What kind of correction I could not follow, madam. This is one.
No, if I have understood correctly,
Hmm.
this corrigendum says, if you come to the category beyond, that this OBC, MOBC instead of OBC with roll number so and so will now appear up to 1040 instead of 21, 40, 60, etc. So earlier, these roll numbers were displayed in under OBC. Correct?
Yes, your lord.
Now it is corrected with the category instead of OBC, MOBC
Movie.
with the following roll numbers, that is starting from 038 to sorry,
With roll numbers 038, 040,
038, 040,
060,
so and so. Then category unreserved,
General.
Instead of
category
general.
category general had earlier contained roll numbers 020, 021, etc. Now it has been corrected as
It has
unreserved.
been
General-
brought into the OBC category.
My lord, general and unreserved is the same thing.
So they have corrected it,
No, no,
whatever it is.
the, instead of general or unreserved, it is the same thing. It is not that from general to OBC or OBC to general. They do not say that.
No, you are raising this question of 2021 being
Now they have.
thrice.
Hmm.
So they are just indicating a correction that instead of this category unreserved is to be read instead of general with roll numbers so and so, including 21.
My lord, general and unreserved is the same thing, my lord.
Yeah.
General means unreserved, unreserved means general. Their corrigendum ought to have been, my lord, instead of OBC,
Where is the advertisement?
my lord, at
At
page 15.
15 of the writ petition.
So what does the advertisement, how does it reflect category?
Categories lordship, if your lordship
No, we
can,
are asking the petition.
Yes, my lord, page 15, serial number B, OBC, MOBC 2, unreserved 7.
That's right.
Ah.
So it was not,
That means
Advert-
general, my lord.
it was not advertised as general. It was advertised
That
as unreserved. Therefore, the correction.
No, my lord, that and unreserved and general is the same thing.
That's right.
Synonymous.
It's synonymous, but it was not advertised as general.
But my case was that, my lord, he was shown to have cleared the written test as general category candidate and selected as an OBC candidate. Then the manner corrigendum ought to have been instead of OBC or general OBC. His case should have been in the OBC category. That was not given. That was not that way.
That is the correction which is shown here.
Instead of OBC or whatever OBC. In my case, instead of general.
Where is the earlier notification? Corrigendum was issued in response to
notice dated 19 February,
page number 17.
page 17 of the writ petition. Your lord. And if your lordship takes up page 76 of my affidavit in opposition, that is the corrigendum, your lordship. Issued on 20th of February 2014, your lord.
Yes.
Hello. Yes,
What are you trying to point out?
no, my lord. In the page 70, lordship has seen he has shown to have cleared the written test as OBC candidate, sorry, general category candidate, but given appointment as a reserve category candidate. Therefore, my lord, in my humble submission, corrigendum ought to have been instead of general OBC.
That is what they have written here.
They have written OBC, MOBC.
Ah.
He has not cleared as OBC or MOBC. He was shown to have cleared the written test as general category candidate.
That is what they are trying to correct. That his name ought to have been there as OBC or MOBC.
But it is not clear from the corrigendum, my lord, that way.
I do not know. It appears to be very clear to me.
Anyway, my lord, then another point of argument is, my lord, he may be a general category candidate, my lord. But if he has appeared in the selection process as a general category candidate, his case should be considered along with all other general.
So what is the selection report that, where,
Lordship, both the petitioners and the respondent belong to the OBC category.
your record, what do they say?
Record says, your Lordship, roll number 38, he is a OBC category.
How have you conducted the selection?
And my lord,
How have you conducted the selection for these two candidates? What does your record say?
in my affidavit in reply, my lord, I have specifically stated that the respondent number 4 has not put his signature in the OBC sheet when he appeared for Vaibhavasi test. I have specifically stated, Lordship therefore directed on 21/7/23 to produce that record also.
That record I do not have, your Lordship.
He may be a reserve category candidate, my lord. If he has appeared as a general category candidate, then his case should be considered along with all other general. There is a government notification to that, my lord, central government.
Where are the records of the examination? Who appeared on which date? Where are these records?
That Lordship I have not been handed over.
Why?
Otherwise, I have the application forms whereby
That you have already enclosed.
Lordship, those were
That you have enclosed. You get the selection record.
Lordship.
Are they available?
I'll have to ask the concerned officer.
Get it.
Regardless of how they conducted whatever they did, I applied as an OBC. That record is available.
His contention now is that you may have applied as OBC, but on the date when you appeared for the Viva, or what Viva,
Vaibhavasi.
you did not sign as OBC. only.
And that statement is correct
Made
as a
by,
matter of record. But he has access to the record. That's all.
I don't know whether it is.
No, because
I can't
it
give
is
that answer.
it is not my
Of
statement.
course you can't. Therefore, we are asking.
can.
Statement of my statement of the petitioner on affidavit, he said definitely will definitely when he put his signature, definitely he will also know because 38 will come earlier. His roll number is 60.
Get the record. When you can get it?
Lordship, 2 weeks time, because Lordship, 1 week time. I'll get it.
Sixth of June.
Got
Please take it on 6th of June, enabling the cooperative department, Standing Council Cooperation Department to procure the records pertaining to selection conducted for the post of peon in the department where the petitioner and respondent board had appeared. So the record should also contain records must also reflect as to how the Viva Voce was conducted with respect to petitioner and respondent board. Sir, Rafathar board, list on 6th. of
Clear.
June.
Other- Ajit- Ajit- Right.
In this matter, I'll be filing my affidavit, my lord. On the last occasion, your lordship wanted the rules, which rules is applied in this matter. My lord, I'll be filing an affidavit also, and my lord, just to place the rules, I'll place it.
Where's the route?
This was,
You
my
were
lord,
appointed by the irrigation department,
irrigation.
placed in the secretariat.
And
Nazaran. Now you want to participate in the grade 4.
No, he wants a promotion to the next higher post.
What is that post?
LDA junior.
Now,
LDA junior assistant.
Hmm.
Where is
Grade
the cadre
three.
here?
Grade 3.
and my lord, our contention is that, my lord, since he has been appointed by the irrigation department, the rules, my lord, the Assam Secretariat Grade 4 and Record Supplier Service Rule, there the appointing authority, who is the appointing authority, the definition already is given, man. And I'll be bringing certain more facts, man.
These are your rules.
This Lordship will come to the first page, my lord. That is, there it's given appointing authority.
What are the where is the cadre? What is the strength? Cadre strength. Which post are you working now?
He is Daftari.
Daftari.
That is, my lord, it will follow. Should find that the third page. There, my lord, Daftari B. These are, my lord, people who have been appointed by the Secretary Administration Department, not by some other department. That is what I'm on, my lord. That is why first page which is page. There it is given appointing authority means Deputy Secretary to the Government of Assam in the Secretariat Administration Department. And in case there is no Deputy Secretary, then any other Secretary in the Secretariat Administration Department. Now, my lord, if your lordship comes to the writ petition which he has filed, if the main page, the first page, one,
You are
annexure 1.
Appointed as what? Daftari.
Daftari. Grade 4. That's grade 4. And my lord, if your lordship comes to annexure 1 of the writ petition, that is the appointment letter. That has been, he has been appointed by an undersecretary of a Government of Assam Irrigation Department. Not, and the rule says appointing authority has to be from SAD. So therefore, my lord, I will have to bring that on record, my lord, in the form of an affidavit. That particular stand which is there, he is a irrigation department, my lord, appointed by them. Had he been appointed by the Secretariat Administration Department, then it would have been a different thing, man. It would have been a different case. That's what I'm trying to project. Well, some time may be given, I'll file the affidavit, my lord.
Let us see your appointment letter. It type.
Page 15. Page 15 in my writ petition.
Page
15 1 5.
Annexure 1. Page 15.
Annexure 1.
Then
Till now, like Lordship, I am working in the state department as a grade 4 employee since 1989. Thereafter, Lordship, I am acquired some qualification for promotion, Lordship. Page 21, Annex 4, this is my qualification certificate, Lordship. Provisional certificate. SK Hazarika College Study Center. Lordship.
Nice, sorry.
Become final. Thereafter, I have submitted a prescribed format, Lordship, Annexure 5, page 22, Lordship. This is the format to my parent department, irrigation department.
now, Mr. Ikwan,
My lord.
please come to page upper. Please come to this annexure 2, page number 16 of the writ petition. There is a set of rules.
My lord.
If you come to page 17, you will find the cadre.
There is another rule, Lordship, the Assam Secretariat Grade 4 and Record Supplier Service Rule. Where defined the doctor and grade 4.
That I have given, my lord. I have given that.
No, you have given, but we can't find the cadre. That's what we are asking. Where is the cadre?
That is in the other one, my lord. Other, my lord. Two rules. This applies to, my lord, this will apply first, my lord, we have to see who has given him the appointment. So for that appointment, my lord, first,
First, who was the kidder?
Where is that?
Where is the kidder?
My lord,
Kidder? Route 4?
Huh?
Yes.
my lord,
Rule 4. Route 4.
yes, my lord, rule 4.
Upper division, lower
Status of service.
section.
Which routes are applicable?
My lord, that is the question, my lord. In this case, that is the,
Forget that he is appointed by irrigation.
well, otherwise subordinate service rules is applicable.
Which is that?
Subordinate service rules, my lord, which is the Assam Secretariat Subordinate Service Rule 63.
63.
Yes, your lord.
Coordinate service.
Hello?
Then why is the grade record supplier?
My lord, why I have given that? Because these two are applicable. Because first, my lord, when he joins the
Rather,
my lord,
question 2.
my lord,
Question is the post which is asking for promotion.
that post, my lord, he wants promotion to the next higher post from Dafri. But the issue out here is that,
I am asking you a question. Give me the reply you have. What is the clinic promotion?
I don't know.
You don't know.
I don't, my lord, this post I don't know because of the fact that I don't.
You don't have a copy of the writ.
I have one.
Lower division, section.
Lower division.
Huh?
LDA.
LDA, lower
LDA.
division, junior.
LDA.
Clause 8, lordship, in this service rule 1963 service rule. Assam Secretary Subordinate Service Clause 8 is
When I ask you question, you give me the answer. Don't tell me from A to Z. I am asking you a question. If you don't say yes or no,
Okay.
both of you.
My lord.
Now you come here. Which post are you claiming for promotion?
Clause 4, rule 3, lordship, lower division.
Lower division. Lower division, you'll get only from typist. You are not a typist.
No, lordship, I am doctor.
If these rules are applicable, Peter Gatter is typist.
Typist, selection grade, ordinary grade, this is also promotional post.
You do one thing. You study properly, come back next week.
The question goes by learned.
No, question which we are asking you, you are unable to give the answer. Either you say these rules are not applicable or you say these are applicable.
Rule is applicable.
Then if it is applicable, your post is not even there.
Yes.
But
Junior assistant post is there.
where is it? It is not there in the cadre. That's what we pointed out, rule 4.
Lower division assistant. This is the next higher promotional post.
From typist. Are you a typist?
No, look, I am not
Then?
typist, doctor.
Doctor is not even mentioned there. Yes, next. Next week.
I'll file my affidavit, my lord. I'll file. DPM.
Lordship on last revision, Lordship had the matter.
Method is all very hard.
Punishment transfer.
Punishment of control. And the relevant record is also produced.
You had relied on some judgment.
I have given Sumesh Tiwari.
Sumesh Tiwari.
Lordship.
All right, we'll pass order.
Lord.
Heard this post. Pass order.
Deeply affected.
Maybe the lot. But meta request to prolong suspension.
Yes, GMC.
GMC.
Who's for GMC? Yes.
My senior is on leg.
Your senior can't be there in all court. You have to help him. You have the brief. Read it. What instructions have you got? Hmm? You filed, but why have you kept him under suspension?
That, so extension order has been deferred, Lord, and the department proceeding to now take date. Just waiting on the file. because That is, yeah, that
Where is your suspension order?
51. Not 51.
By what? By
Case
what?
51. 24/10/2022.
You are serial number 3.
Yes, which we have.
All right. Then
That my lord, subsequently, my lord, so far notice was issued, my lord. And my lord, case 55, my lord, that bail was granted, my lord. Last paragraph, my lord, case 55, my lord, some conditions were also there.
yes.
Then, my lord, subsequently thereafter, my lord, as my lord, it was not reviewed, my lord, within the 90 days period, my lord, we approached this honorable court, my lord. And my lord, this honorable court, I order dated, my lord, 24/5/2023, page 73. And my lord, 11
come back to the suspension order again.
51.
What is that 57? Departmental proceedings were initiated.
Yes, so-called notice was issued. And my lord, I submitted my reply, my lord, but my lord, during the 90 days period, as it was not reviewed, my lord, that extension of the.
Oh, but they've they've proceeded to take
Yes,
proceedings before expiry of 90 days.
yes, my lord. Then, my lord, we approached the honorable court, my lord, and my lord, this honorable court, my lord, you will get at page 70, page 73, and my lord, relevant portion, my lord, 74, my lord. Well, upon hearing the learned counsel for the parties and taking into account that the memorandum of charge was issued so and so, and the petitioner has also submitted its replies to, and the discipline proceeding is presently going ahead with the criminal pending. This court does not find any rational ground for interference with suspension. However, it is made clear that it is the mandate of the law that there has to be extension of the suspension order by a reasoned order, which, as per the office memorandum dated 4/2/2020, is to be done within a period of 6 months, taking into account that the learned counsel appearing on board the so and so submit the same would be done within a period of 15 days from today. This court is not inclined to interfere with the order of suspension or the further continuation of suspension, subject to the respondent authorities passing a reasoned order within 15 days from the date of certified copy of this order is so. And in pursuant of this order, my lord, that they have passed the impugn order, that the authority will get it on page, my lord, 81. On the 15/6/2023 order. Made it. Whereas so and so executive engineer Guwahati Municipal Corporation was placed under suspension with effect from 24/10/2020, high order number so and so, in connection with Vigilance Police Station case number 4 of 2022 under section so and so. Whereas the departmental proceeding initiated against Corporation high order number is pending due to his non-availability as was SST and for judicial custody. Whereas during the investigation, some of the relevant official record document files were taken by the concerned official, Chief Minister's Special Vigilance Cell Guwahati, Assam, and the same is still in custody of Vigilance Cell. In view of the above, compiling the facts and circumstances, suspension period is extended, and also departmental proceeding of the so is temporarily deferred until further order during so. And my lord, So, my lord, they have expressed their inability, my lord.
What has happened to the criminal man?
Criminal is pending, my lord. It is a very initial stage, my lord. Copy has not been served till date, my lord. And in the meantime, my lord, two of the accused, my lord, has already been, my lord, reinstated, my lord, in pursuant to that peace memorandum dated 4/2020.
You are receiving your subsistence allowance.
Yes, my lord. And my lord, very recently, my lord, in their affidavit, my lord, they have again, my lord, restarted the departmental proceeding. But they are failed to, my lord, to provide the, my lord, to official record to inspect. My lord, I have filed one additional
So
affidavit.
you are essentially praying for seeking enforcement of the suspension order.
Yes, my lord, initiate, my lord, and that extension, my lord, in extension order.
What is that notification that you are referring?
My lord, 4/2010.
Some notification was there.
Yes, my lord. Plus you will get it page 70, my lord. May I read? Office memorandum, Honorable High Court, Guwahati, in its order dated 30/11/2017, in a series of writ petitions, the lead case being so and so, has directed to issue a notification indicating the law laid down by the Honorable Supreme Court in Ajay Kumar Chaudhary versus Union of India, case to the effect that the disciplinary authorities are to be strictly comply with the requirement to issue the memorandum of charge sheet before the expiry of 3 months from the date of issuance of the order of suspension. It is therefore directed that all the senior-most secretaries of all the departments shall ensure that memorandum of charge sheet is served to the delinquent officer employed before the expiry of the 3 months of period from the date of issuance of order of suspension. They shall also ensure that the currency of the suspension order should not extend beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent officer employed. If the memorandum of charge sheet is served within 3 months of suspension, a reason order must be passed for extension of the supervisor of wherever is necessary. The officer proposing for suspension shall also ensure that the charge frames are submitted to the disciplinary authority within 2 weeks from the date of passing order of suspension. After issuance of memorandum of charge sheet, the senior most.
You have not filed a rejoinder affidavit.
Yes, ma'am. We have filed.
You have filed.
Yes. We have filed our additional affidavit on 24/1.
Additional, yes. But after the affidavit in opposition, have you filed any other affidavit?
Yes, ma'am. Reply we have filed.
You have. In 6302.
Yes, ma'am.
Okay.
On 25 to 20th of May, ma'am.
Not yet. No, it is not here. If you have filed it, it is not here.
Filed on 20th of May.
Not here. Reply is not here. Right. You come next week. Mr. A. The joint have been filed. The affidavit was filed by the respondent or probable statement connected to the case report. It submitted that the joint affidavit was filed on
20th of May.
20
20.
20 May 2025. Next week, trace out the data stated to have been filed. And connect it to
April.
date for the respondent. Next week,
30th of month, I will be out of 30.
30.
30.
Okay, it's on 30.
But today the time may not permit. Can it be on 30 Miller, 20,
P0.
or some other date? Miller?
This we had already heard, I think. This is that.
No,
No, this is not
No.
that. So I thought it was.
no, Miller. It'll take some time.
It is that
SCS.
certificate.
No, not certificate.
Same name, I think.
No. That is monsoon. This is Sanghamit. I think today the other side has taken time.
Here, yes.
Let me fix my lot.
Not that they buy me.
How
Not
about
I-
have it on 10th?
Let-
10th of June.
Or 9th, Miller. 10th, 10th,
10th of
Tuesday. Yes, that will.
item.
Deep.
Item 14. What about 13?
Oh, their AG has taken time, Miller.
Okay. So therefore, I was asking you, the names appear to be similar.
Lordship has fixed that case on 5th of June.
All right. 14th, 14th
14 on 10 to Miller.
or 10th.
Yes.
Item 14, 10th of June, 3 people.
The 16, 17 minute.
Hmm.
This pencil matter, some urgency was there, and lot will fix some other day. Let the
The courtmaster will fix a date. We will.
first week of June. Lot.
What is item 15?
15 is ours.
16 and 17.
15 is what? What matter is 15?
It is
Financial upgradation. We are disputing the financial upgradation against AIDC.
Financial upgrade.
Yes,
stagnation as a
Stagnation.
service. She has been working in one post for
You are
10 years.
disputing.
yeah, they've actually not given us the right pay scale.
You want the direction to them to give you financial upgradation.
That
Yeah,
has been given, Lordship. However, they're not satisfied with what has been given.
they've introduced a new scale which we are disputing.
We'll pray for a date if Lordship pleases. It may be fixed on 12th of June, as we have agreed on both sides, and that is the
12th
BD
of-
course
12, right, 12.
obliged.
Sorry, item 19 and 20, your lordship, in the last occasion heard the matter, item 19 about gratuity. date may be fixed, the next Thursday. In 19, we have otherwise completed our argument. It's 7.
Next, next Tuesday.
March